Good afternoon to all of you, and thanks for joining us here for closing arguments on Ihsan and Zahraa Ali in the what's been deemed the attempted honor killing or attempted honor hurt inflicted on their daughter. So closing arguments are supposed to be starting soon. This is a case that we haven't really been covering so much on the channel. But, you know, we always enjoy closing arguments. So trying to get caught up on the case as much as I can to be prepared for the closing arguments. Seems like there was an arranged marriage that was arranged, and the daughter wasn't too excited about that. So she didn't really want to go through with it. And from the reports, at least, and again, I haven't seen the entire trial, but we are going to watch the closing arguments. So they were not so happy. And when you cause disgrace to the family in such a way by refusing to enter into marriage with who your parents deemed, I guess, a good marriage, good partner, then things can get a little sticky. And it seems like that's what happened here. So there's this video. Then they also charged the wife, the mother, and they also just added some charges in the middle of a trial, which does happen. Sometimes that happens where in the middle of a trial, they will add some charges. So some domestic violence charges were added in the middle of the trial. So it definitely seemed like an interesting trial to watch. Unfortunately, we were completely bogged down with a lot of other trials or other cases going on, including the Brian Walsh case, Turtle Boy, got Adelson. We've got, some other cases that have been taking my attention away from this. But closing arguments, I figured let's stream it. Let's see what happens. Let's see how the lawyering goes, and maybe we can get a feeling from just the arguments about how this verdict is going to come out. Seems like the evidence is stronger against the father than it is against the mother. The father was the one to be more active, not the mother. So we'll see what happens. But this is all we see right now from Court TV. That's what we're going to be using to stream. So appreciate Court TV for streaming this. Looks like they're having some technical issues. Look at that. Stand by. And if you guys have any other channels that are streaming this, I'm pretty sure Law and Crime Network is not. So I can take a look now while we're waiting. So while we're waiting, I'm just going to remove myself and look for other. Well, I'm not finding any on my quick search. If you guys have another channel that we can stream it from, let me know. Meantime, let me say hi to some people here. Rootber Float, thanks for joining us last minute. See you soon. Sidebars and Side Eyes. Hello, Broco Bunch, formerly known as Hiding in Bev's Bangs here. So it looks like we have a change in the name here. I think a lot of people liked Hiding in Bev's Bangs. I think they like that name. Sarah Stiles, looking forward to this. Bridget, I think some of the charges on the mom are thin, but the dad will be convicted. Seems like this video evidence is pretty strong. LLH, I'm so happy you're covering this. Thank you. Yeah. Seems like it was a pretty short trial. What, about 9 days? A little bit less than the Karen Reed case. Anyway. Bridget, the judge's rulings made this case hard to follow. The video is everything. So, yeah, that's why I need to watch the trial with a trial lawyer so they can explain what's going on with the judge's rulings. Can't believe the defense wanted to say in the culture it's okay to do this to your child and they didn't know any different. You know, I mean, what's in the culture? What is okay to do to your child? To have an arranged marriage? I mean, I know some cultures have arranged marriages, but what about when your daughter doesn't want to go through with the arranged marriage? Is it okay in your culture to take the actions that were taken in this case? I mean, that's not okay, right? I mean, this is America after all.
Because she was at her wit's end, you know, so side of mom and dad went too far.
What about mom compared to dad? And so far, we haven't seen a lot during cross-examination from mom's attorney reminding the jury that.
Okay, well, it looks like they're going to some analysis before closing arguments there, so we'll just mute it for now. And here's where Bridget says, what do you think about the added DV counts? I mean, it's possible through, you know, in the trial to add counts. That happens sometimes. Linda Mitchell, good day, everyone. Miss Miles Selena. Good afternoon to you, Chris Robinson. Good morning, all. It's great to have all of us here, and we always miss BC when he's gone. Best channel. Thank you, Chris. And we definitely had a good time watching the Karen Reed trial. That was a good time. And we have some trials coming up. I think we're going to stream also. I know I like to do Adelson. Definitely Brian Walsh if that goes to trial. Obviously, some big news in Brian Walsh recently. I guess you're going to look at the video. Sybil C. Hello, everyone. Best channel. Good morning. Bijou Cooper. And our mod is here, Blurry Lights. Thank you for joining us, Blurry Lights, and being here. Make sure that everyone's behaving in the chat. Going off the rails. Hi, all. Jen. Sandy B. Hello to you. Tall Red Texans. Hello. And B. Good morning, Martin. Good afternoon to you. Okay, we're still waiting on closing arguments or court to start. Looks like they're just playing some other things. If you want me, I'll unmute it.
Here.
Yes.
About what?
I'm dying.
Where inside the school?
Straight to the office.
Did you tell them anything when you got there?
Yes.
Yeah, what did you say when you walked in?
He was trying to kill me.
You have shared with the police and with others that you felt like your mom wasn't trying to hurt you. Fair?
Yeah.
Okay. Your mom is just there holding you as you regain consciousness, correct?
Yeah.
Difference in the way Fatima testified about her parents. We're actually getting word that closing arguments are about to start there inside of the courtroom.
Yeah, they're convening now. The jury has not entered the courtroom yet, so let's get a break. And when we come back, we'll hear from both sides, all three sides, as the closing arguments in Washington versus Ali begin. Stay with us.
All right, well, it's going to be happening soon. So as soon as they go live, we will. But we've got Bijou, and again, I know I'm probably pronouncing it wrong. Cooper. Hello, mods. We appreciate you. We definitely appreciate the mods. Hello from beautiful Oregon. understatement of the chat so far. Sticky is one thing. Attempted murder is illegal. Yes, 100%. I did not mean to play down what happened here. Of course. Jessica Lee, I'm at the dentist's office with my girl, so glad there's a live. Yeah, I mean, you can be at the dentist a long time. And we got a few kids. It feels like you're going to the dentist every other month, whether it's to get checkups, fill cavities, or whatnot. So at least this will keep you a little bit busy, hopefully. Jessica Lee in Georgia. I think Atlanta. Sunshine Mitch, good morning from Connecticut. Sidebars and side eyes. The judge wouldn't allow prosecutors to enter that she was being sent to Iraq to get married. And you can kind of understand that because, that would be very inflammatory to a jury. That you're going to be sending your child off to Iraq. How old was she? I don't know how old she was. That can be so overly prejudicial to the jury. And is it really relevant? And that's where you get into the 403 analysis, whether even if there is some relevancy there, does the prejudicial effect severely outweigh relevance? So. So Mismo SC said, I watched the trial, but happy to watch closing arguments with BC in chat. So I guess if we need some questions answered about the specific details of the questions of the trial, we can ask Mismo. Linda Mitchell, do you think immigrants should be aware of the laws and traditions coming to United States? You would hope that if you're going to be coming into and immigrating into the United States or whatever country it is, that you should try your best to get caught up on all the laws that's relevant definitely to your situation and all the laws in general. After all, this is a country that's nice enough to accept you and to bring you in. Oh, is this? Oh, no, not. Are we starting closing arguments? Let's see what's going on.
Slide 91. 98 through 102.
Well, it doesn't look like they're getting to closing arguments quite yet.
$124 to $127. $138 to $140.
Look at BB Mag 23 is here.
Through and saying them, so that would require me to count, but I did want to try and give that at least as a heads up. Names certainly are used throughout. First names generally only unless it is the alleged victim's name in this case. But in terms of photos specifically that depict them, I wanted to at least give that heads up.
All right, thank you. And Ms. Stone, when we discussed this issue last week, you had estimated that potentially 2 hours for your closing. Do you believe that you can finish that many slides in 2 hours?
I think it is going to be very close. Certainly there's a number of, I would say photographs, video that take up a good portion of that, as I have identified. And there is overlap between several of the charges and evidence. So some of those go significantly faster. My hope is to be at 2 hours. I'm also trying to be mindful of not speaking too quickly.
2 hour closing arguments. I hope you guys have a drink.
I know that we have a.
That's just one side, probably the prosecution.
As well, the other interpreters that we've had throughout the trial have indicated that the pace has been fine. But if for some reason that changes, I would just hope that somebody would let me know so I can slow down. But my goal is to be done right at 2 hours. That's the state's intent.
All right. I estimate that it will probably take me about 40 minutes to read the 49 instructions to the jury. So we might be close to 10 o'clock by the time that I conclude. Once I conclude, I will give the jury a stand-up, move around little break. I don't want to interrupt anyone's closing, and I'll address this also with Mr. Keating and Mr. Leary. But I'm hopeful that you will have some sort of natural breaking place so we can take a 10-minute recess during your closing.
I think that I think there is a natural breaking or pause place so that way folks can get up, to use the restroom, whatever needs to do.
All right, thank you. Mr. Keating, do you have any preliminary issues this morning?
No, I was just going to ask about schedule.
All right, guys. Well, I hope you get comfortable because it sounds like the state's going to take 2 hours. I don't know how long the defense is going to take. Usually they're shorter.
That's my guess, just based upon the
Right.
timing with the estimate for the length of the state's closing and taking into account the time it'll take me to read the instructions. I do, and presuming that's around noon, we'll recess for about 30 minutes. The jury will have lunch, and then we will bring them back in for to start with your closing. Also, on Thursday, you indicated you believed 60 to 90 minutes for your closing. Is that still accurate?
I believe it is.
All right.
I think 60 is actually close.
All right. So if it's 60, then I think that you just give your entire closing. If it's going to, as you're watching your time getting closer to 90, we may want to just take a stand-up break also, just to give them a little bit of a break. And then Mr. Leary, I would anticipate taking a 10-minute recess after Mr. Keating's closing, so that, and then you would provide your closing. And depending on where we're at timing after your closing, whether or not I just do a stand-up before rebuttal or whether or not we take another 10-minute recess will just depend on where we're at. And you indicated that you believed probably around 60 minutes. Do you still believe that that is likely accurate?
Maybe a little bit over, but not much over.
All right. And same for you. If at some point you think it would be helpful to have a stand-up and take, a couple minutes, and or you think based upon the way everything else is going that a 10-minute recess, please feel free to indicate to me that you think it's a good time for a recess, and I would do that.
I appreciate it.
All right. Bring the jury in, please.
All right. Well, looks like we're going to have the prosecutor's closing argument for 2 hours. Maybe they're going to take a little lunch break, maybe one defense argument, closing argument, but there's definitely going to be closing arguments after a lunch break. So you guys are going to have to hang around. So we'll see what we'll do with that. Paul Tim, I've watched the whole trial. The dad is for sure getting time. The mother is 50-50. Amber C says the judge does not allow any info about the arranged marriage into evidence. Could be too prejudicial. Banks says hi. She was almost 18 when this arranged marriage happened or was set up. BJM, yay alive. Thank you, BC. Glad to be here to hear your teachings. And going off the rails, the arranged marriage should have definitely been allowed. It was motive. Yeah, I mean, definitely that is a relevant part to the testimony. The question is if it's too prejudicial, which is probably what the judge found. Paul Tam says the judge said the girl never mentioned the marriage to the police. It could be there's a reason for that. Guardrails, hello from Texas.
Please be seated. Good morning, members of the jury, and welcome back. As I told you when we were last in court, what is left is for me to advise you as to the law that applies to this case. And that law is contained in the jury instructions. You have each been provided your own copy of the jury instructions. The only difference between what you have in front of you and what I have in front of me, the originals, which I have, are signed by me and dated with today's date. And the original instructions and the original verdict forms are printed on white paper. Everything that you have is on blue paper. After I read you the instructions, and I'm required to read them to you, then we will begin closing arguments. We do anticipate that closing arguments will take all day today. And as I told you previously, we have ordered or are ordering lunch.
So she might
and we
read about
anticipate
40 minutes
probably
of,
about a
of
30-minute
jury
lunch
instructions
break.
now.
And we will still have a recess in the morning and a recess in the afternoon, but those might only be about 10 minutes each. All right. These are the court's instructions to the jury. Instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law from my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the
Carol and
facts that
Brenton.
you decide have been proven, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence that the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you have heard from witnesses and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or if I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition.
I'm sure you guys won't mind
Each
if I
party
talk
is entitled
over
to the
the jury
benefit of
instructions.
all of the
So maybe I
evidence,
will do that.
whether or not that party introduced it.
I'll just shut it off for a second. Here, her guardian angel was an Army veteran who passed by and restrained the dead until police came. Now, what would we do without all these, off-duty cops and, people that are out there looking out for other people? Yeah, I'm so glad there were some good Samaritans that helped her and so many eyewitnesses. Paul Tan says they are both being held on bond. The mom tried to escape and took the other kids to Canada. Amber, see, the ruling on the Walsh motion is shocking. I was hoping Auntie Bev was the only one with bad rulings. So I did get those rulings. It was on my plate today to go through, but then I saw we had closing arguments in this case, and I thought maybe some people would want me to live stream it. So we're going to do that. But I do have those Walsh motions the Walsh opinions that I have to get through. And then I'll tell you whether I agree with it or not and talk through some of the legal analysis that the judge gives. But you know what? If those searches were done, I think a lot of people don't want a technicality to not have them admitted. Because if those searches aren't admitted, obviously, it's very, very good for Brian Walsh. JL says, my boss is from Pakistan and his 6 children are in arranged marriage. And if you're just joining us now, the judge is just reading the jury instructions. So not overly exciting. If you want to listen to them, we can put it on, but I figure we'll get through some of the comments now. And Mismo, who's been watching this trial very carefully, says, interesting to me why the eldest daughter, 21-year-old, I think, hadn't had an arranged marriage first. So she did not have an arranged marriage, and then I guess the second daughter did. And again, I don't know exactly how these arranged marriages work in those communities. Did somebody, offer some money? Like, I don't know how all of it works. So maybe the first daughter that nobody offered or nobody was interested. I don't know. And it's all pure rank speculation. So the quick synopsis, Jacob, from what I understand, is that they have a daughter. These 2 people that are on trial now, Ihsan and Zahraa Ali, they had a daughter and they wanted to arrange a marriage with somebody else, and she wasn't too interested in that. And they got into they were beating her up, or that's the video seems like that. And perhaps attempting to murder her, an honor killing. This is what they're referring to as an honor killing, where if you're going to bring your family dishonor, then I guess in certain cultures it's okay to take it out on that person. So that's a quick synopsis of what happened, and a lot of it was caught on tape. The question is if the mother was involved or not. So that's the quick 30,000-foot view of what happened here. So again, Bridget, some people have different opinions on the arranged marriage not coming in. Do you think that was the right ruling? I think so. I have to get a little bit more details on it, but from 30,000 feet, I can understand why the judge would not allow it in. It's one of those discretionary type of rulings where maybe some judges would allow it in, some judges would not. I guess the safer bet would be to not allow it in, even though it's obviously very important in this case, and provides the motive. But I understand why the judge would not allow it in, because it's so incredibly prejudicial, and definitely for your average American hearing about forcing your kids to go through an arranged marriage, that can be the end of the inquiry for you if you're a juror. So I can understand why she didn't allow it in. Marina, good morning for Brazil. Again, if you're just joining us now, the judge is just reading jury instructions, which is generally not the most exciting part of the trial. So we're just going through some comments. Greetings from Cape Cod, Haley. LLH, this closing should be interesting from the defense. Don't believe your lying eyes. They were scared parents trying to save their daughter from American culture. So, I mean, if you're living in America, why do you want to save your daughter from American culture? If you don't like the American culture, then why are you living here? So if that's the argument, I'm not sure if that's going to be the greatest argument, but. Paul Tom says the judge said the girl never mentioned the arranged marriage to the police, so unable to use it now. Okay, so again, I need to know more details about it. And like I said, I haven't been following this case so closely. I don't know if that should be, if that in itself is a bar, just because she never mentioned it, went to the police the first time. I don't know if that should be the reason. If that is the reason, and maybe she had a reason why she didn't mention it to the police. So again, I don't know enough about it, the details specifically, to tell you whether I agree with that ruling. To me, it would smell like a prejudicial 403 analysis. But that fact alone, to me, doesn't persuade me. just because she didn't mention it to the police. Maybe she doesn't want to mention it to the police. Maybe she's scared to mention it. Maybe at that point she was trying to protect her parents. I don't know. But that fact and alone, to me, is not enough. That's not enough to me. Amy, they need to stop calling this the attempted honor killing. It's attempted murder. Yeah, I mean, that's what it is. And of course, BJM, don't forget the thumbs up for the VC. And if you're just joining us now, we're waiting on the closing arguments. The judge is just reading the jury instructions, which is not always the most exciting part of trial. So we're going through some of the chats. And then once they get to closing arguments, we'll play it. And it's going to be a little bit of a while for closing arguments. It's going to take a little while. So just get comfortable, grab a drink, and get ready for it. Jenny Jen, thank you for that. Super sticker $1.99. Thanks for covering this. Much love from Kentucky. All right. I'll take it. I'll take the super sticker and I'll take the love. Thank you. Amy, I don't think it's ever necessary to hide the truth from the jury. Yeah, I mean, it comes down to rules of evidence, and even though some things may technically be the truth, we can't always admit certain pieces of the evidence in front of the jury. That's just the way the rules are. So I know that the feeling is let's just put everything in front of the jury, but we have certain rules that we have to follow. Brooklyn says age of consent in Iraq is 12. I don't know if that's true or not, but and sidebars and side eye says relevant because this happened the morning she was supposed to leave for Iraq and ran away. Defense used that to make her look like a brat who didn't want a vacation. I mean, they're just going to go to Iraq for vacation, not to have an arranged marriage. Conversations of Light said I watched the whole trial as well. So we got some very knowledgeable people in the chat, so they should be able to help out with some of the details if you have questions. Sharma Lily, I've been following this case pretty closely. It's despicable. He tried to kill his daughter in front of everyone. You know, I mean, that wouldn't be the greatest place to kill your daughter. But maybe she's trying to get away. JL also watched the trial. M. Katz, thanks, bro, for covering. Yeah, closing arguments are always interesting. So we'll see. It seems like there's a lot of interest in the case. Although I definitely do have stuff to do. But I thought you guys would appreciate that. We're covering this case, so that's what we're doing for closing arguments today. Anyway. Kimberly GNYC says she ran away the day the mom was taking her to Iraq on a one-way ticket to marry a man in his 60s. Parents didn't like the fact that she had a boyfriend. Really interesting. Is that true also? Like that the arranged marriage was somebody in their 60s? I didn't know that fact. Hope the mics are loud today. I hope so too. And again, if you're just joining us now, we just muted the jury instructions because they're not too overly exciting. Maybe more exciting talking about some of the comments here in the chat. Amber C, thank you for becoming a new member. Appreciate that. Winter Sky, thanks for covering this. So Kimberly GNYC was watching this, said they weren't allowed to talk about the arranged marriage in the trial, but the jury knows she had a one-way ticket. So they didn't know that she had a one-way ticket. Okay. Going off the rails, for years I helped women escape polygamy groups here in the U.S. There's an entire underground railroad for it. Wow. And again, there is no sound if you're looking for sound right now. You just muted it because the judge is just reading the jury instructions. Paul Tam says that two defense attorneys said they needed an hour each. So we're looking at 2 hours for the prosecution, an hour of each defense attorney. That's 4 hours right there. But there's going to be a break. There's going to be some breaks in between, so you don't have to worry about that marathon. Yeah, I mean, it's interesting. On a 9-day trial, you get 2 hours for closing argument. And in the Karen Reed case, they got an hour and 15 after like 36 days of trial. Stylish Bacon, hello from Finland. And this is in Washington State. So over there, it's only like 9:30, 9:40. Mom P. Texan, if these parents wanted to do this cultural thing, force daughter into arranged marriage with a much older man, they should have moved back to Iraq. Stylish Bacon, brother, have you seen the rumor gossip and innuendos cultural approach chat about this? So interesting. No, I haven't. Tinfoil Hat Society says video says it all. Video evidence says it all. At least she's 18 now. Guaranteed defense could have explained culture if the arranged marriage had been brought in. Yeah, but I think at that point it doesn't, you can't explain away that. It's one thing if your culture says, you have arranged marriages, but what happens if they don't decide not to go through it? Then you force them. And if they don't, then you kill them. I mean, there's no explanation there possible. Well, Brooklyn says that she was 18 and was going to marry a 40-year-old in Iraq. So I heard 60-year-old. Now I'm hearing 40-year-old. Saudi girl, I didn't know you were airing this trial. Well, I wasn't until the closing arguments. I figured, if there's closing arguments today and we can start off clean by the closing arguments, let's do that. I said conversations. Conversions of light. It's just insane that he did this outside of her school. What do you think he was going to happen? What did he think was going to happen? It's insane. Good afternoon, everybody. Crafty Chris. Amber Seas says, can't wait for your Walsh analysis. Yes, I got to read. There's 2 opinions to read through. So I got to read through the opinions. I got to see if I agree with the judge and then explain to you why I do or don't. Kimberly G. NYC, yeah, Brother Counsel, thank you for covering this today. I watched most of the trial on Court TV because no one was covering it. Yeah, it seems like no one was covering this trial. I kept seeing it pop up on Court TV. No one was really covering it much. Maybe because the summer people get a little bit lazy. But I was just bogged down with some of the other things. I actually have a trial myself coming up. We'll see if that ends up settling. Anna Long says an article said they are trying to claim self-defense. Didn't look like it from the video. Mama says her boyfriend was also black and his family had to get a restraining order on the mom before the incident. Magenta says, wish you had covered this from day one. A highly interesting and sad case. Definitely seems that way. In terms of the older sister and why she didn't have an arranged marriage, Amber says, my understanding is older daughter was making better choices in schooling, boyfriend, etc., so they didn't push her into an arranged marriage or what they considered a better choice. Karen T says, Mom inquired about her husband, safety and well-being, multiple times, but never inquired about Fatima if she was hurt or okay. Tuning in from Liverpool, visiting my family from Australia, so I forgot I can watch you way earlier. Glad you joined us. Judy F. says, I think the Walsh judge took so long ruling because she wanted the evidence to come in, even though technically it shouldn't. See, this is one of those things that sometimes happens. You know, you got such incriminating Google searches, and if they get left out on a technicality, even though it's an important one, you know, obviously the Fourth Amendment is an important amendment. Every amendment is important. Sometimes the judges, you know, they got to think about how we're going to get this in anyway. You know, what's the legal analysis to allow this in because it's just, you know, justice requires it. So. Mary Ellen Donovan, my friend had an arranged marriage. She went home to be married and got back to the U.S. as quick as she could. What, with her husband? Leah Simpson says, I'm sorry, but if you're going to be in the U.S., you need to acclimate. We don't do honor killings or arranged marriage. You know, you got to be willing to assimilate in some way when you're living in whatever country is allowing you in. Whatever country is being nice enough to allow you in, you got to adapt to their culture at some level. And here we go, stating the obvious. There's no excuse to choke your daughter. That's right. Elena says people still arrange marriages. They just aren't usually marrying off their child to a senior citizen. Yeah, no, arranged marriages happen. It's just, let's say the daughter doesn't want it. What are you going to do? So what you should do is say, okay, we're not going to force you to marry him. Maybe we'll arrange a different marriage. So if in your culture there's a thing of arranged marriages, then technically there could be something okay with it. But if either the people don't want to do it, well, then that's the end of it. And move on. So happy you're covering this. I have been following the trial. Thank you from Norway. Racer Girl. Hi all, BC and mods. And there we go, Brooklyn. People get married all the time in arranged marriage and live happy lives, but that doesn't mean they can force her and kill her if she refuses. That's exactly it. There you go. Warm welcome to our international viewers from our mod, Blurry Lights. Tall Red, our arranged marriage is allowed in America if there's consent. I would think so, but I have no legal knowledge of it. Yeah, there's no reason why not. If both people consent to the arranged marriage, you can go ahead and get married. You can marry anybody that you want. However it was arranged, whether it was arranged through dating, whether it was arranged because both parents of the partners decided it was a good marriage and they met and they're okay with it. What's wrong with it? Nothing wrong with that. Well, here we go. From Karen, they were receiving a dowry for her. It would make a little more sense. Someone was paying for the privilege. Not that it makes sense, but I watched the entire trial and bothered that both parents are claiming to not understand English, but other evidence testimony supports otherwise. That could be they have a working knowledge of the English language, but maybe, for every little word they want to make sure they understand 100%. Stylish Bacon says, rumors and innuendos. Those cultures, male can honor kill female if it is in a public place. Imagine that. This prosecutor has been so hard to endure. Laborious, tedious manner of eliciting information from witnesses. Jurors falling asleep during her direct. Well, we're about to see a closing argument from this prosecutor, so if it gets too boring, maybe we'll just shut it off. Ainsley Plain Jane, are you aware of any federal or Michigan laws that protect against forced marriages? Well, again, forced marriages, no one's allowed to force anybody else to do anything. If there's no consent, you're not allowed to force them into any marriage, from what I understand. I didn't do research on this, but it's pretty intuitive. You can't force people to marry other people. So I didn't do any research on it, but there's got to be something there. Bridget, how long is too long of a closing? Well, the truth is that it depends what type of evidence came out. But for a 9-day trial, you would imagine that 2 hours is pretty long. Now, that might be too long, 2 hours, I would think. Conversions of lights. It's hard to listen to these attorneys. BC, just be warned. Okay, well, I mean, look, if it's too hard, then we may just cut it and let you guys all watch the court TV stream. Okay, but I'm going to do my best to sit through it and listen. Okay, Schmidt says, great interview with your brother about Turtle Boy. That was yesterday for all of you joining us now. We did a interview yesterday. I mean, an interview. We had a discussion with my brother, national trial lawyer Solomon Radner. And that was a great conversation, like it always is, about the Turtle Boy charges. By the way, I did want to do another video today on the Turtle Boy charges because there's something interesting that I was researching that I want to share with you. So we'll see if I get around to that, although these closing arguments are going to be a little bit of a long time. But we'll see. Maybe I'll get around to it. But thank you very much. And again, if you're just joining us now, we muted the jury instructions. And as soon as they go to closing arguments, we'll unmute it. So don't worry. If you really want to hear the jury instructions, we can unmute it now. But I think she's going to be wrapping up hopefully soon. The trial channel covered it. All right. My buddy, the trial channel. He does great work, he or she. So again, we did close the sound because it's probably more interesting to talk about the comments than to listen to this judge read jury instructions. Karma, Diharma, Tully sent fake grand jury summons to Lindsay Gattani to lure Turtle Boy to apartment. Yeah, so I heard about that, and I didn't really want to comment so much about it because I wanted to see if that's in some sort of document. If it's in a document, then I could have. I just don't remember. Again, there's a lot that I'm trying to research now and look into. I just don't remember seeing that specifically in a document. But yeah, that's what I heard. I heard that there's some sort of allegations of a fake grand jury summons to LG. by the way, Lise, thank you. Been following BC since the second Karen retrial, but haven't been very active in the chat. Well, we do have the greatest chat, so. Stephanie Sweeler says the judge and Walsh decided that the bad guy rule trumps the Fourth Amendment. Well, again, I have to see the analysis. Well, let me take a look at the analysis, and I'll tell you whether that's what I think is going on. David McIntosh, hello from Edinburgh, Scotland. Martha Ivy became a new member. Thank you for that. Stay with us, BC. Well, I'll do my best to stay with you, but I mean, I'm getting apprehensive about the lawyering. Some people are letting me know in the chat. Smart Fan, do you know if you've had any of your trials streamed? The answer to that is back in the times of COVID, I tried a case where every single trial was being streamed to YouTube. And that was actually up on YouTube for a little while. It was just audio. But that was a trial that I won. And it was up for a little bit, but then they took it down. So that was the only trial that was newsworthy. Well, I guess it wasn't newsworthy, but it was just because around COVID times they had to close the courtrooms, and therefore, in order to accommodate an open courtroom, they streamed it to YouTube, and anybody that wanted to could have watched it or listened to it. But that was the extent. So that's all I've got. Sorry. Winter Sky, do you usually do work while listening to trials, etc.? So I know a lot of people do. The issue that I have is that I very much do my best work when I am 100% focused on the task. And if I have anything else that has my focus, then I'm not doing my best work, which is why I like to try to stay 100% focused on one task at a time. And I know it's difficult because a lot of things are pulling your attention. And I know people just like to hear it in the background, but if you're going to be hearing it in the background just as like, casually, then you're not going to be really being able to understand it and get a good analysis on it, which is, I want to be able to, if I'm watching a trial, I want to be able to understand everything going on. I want to have a good analysis, a good take, a good understanding, and then I'll be able to talk about it. And if I'm writing a brief at the time, then I want my full focus and attention to be on writing the best brief that I possibly could. Or if I'm doing research, I want to make sure that I'm reading the cases, understanding them, and being able to apply them to my situation. So if I have anything going on at the same time, it's maybe some music where I don't even have to think about it. It's just kind of there playing in my ear. But I don't like to try to split my attention to two different things. And because my work, I think my work product is very important to me. And the only way that I can do my best job is if I'm fully focused on it. I can't play anything that is going to take away my focus. So I think that's a long way of saying no. BJM says, I do not enjoy court TV, but you are the rock, BC. Thank you. So the charges in this case, from what I understand at this point, is second-degree attempted murder, second-degree attempted kidnapping, first-degree attempted kidnapping, second-degree assault, domestic violence, fourth-degree assault, violation of a domestic violence protective order, and second-degree burglary. And that was for entering school property when there's a no contact or restraining order. Unlawful imprisonment charge. Okay, so kind of gives you an idea of the charges that I saw. Martha Ivy, really enjoyed you and your brother's work yesterday. I found it very educational. Yeah. Solomon's a great guy, and I like having our conversations with him. We usually talk a lot about law, a lot about theories of arguments, things like that. So, okay, let's see what they're doing right now. Maybe just getting up to stretch. Let's see. Ginger says, I've been thinking about signing up for the federal /state grand jury. Do you think the process they take to do background, like social media, etc., on a person or other types of research on you?
All right,
No.
we'll have everyone have a seat.
I'm sorry, I don't know the process. I don't think
Members of
anybody
the jury,
does.
if you would please give your full attention to Ms. Stone as she makes closing argument on behalf of the plaintiff, the state of Washington.
All right, here we go.
Counsel. Ladies and gentlemen, so a couple of weeks ago when we came in and we started this, we indicated you would be here for several weeks, and there was a lot of information that you were going to get. We have reached that point where you've now been informed on the law by the court. You have a fairly lengthy packet of instructions, and you've heard a lot of evidence over the course of the last several weeks. I will tell you that there is no fast way to get through all of that evidence and compare it to the instructions. The court, I think, has informed you, and you'll hear it again. The state has the burden. That is properly the state's burden, and the state accepts that burden. But what that means is I am responsible for proving to you every element of every crime that has been charged. So we have to take some time to do that. And then at the end of this, because it's the state's burden, we get to talk to you again. I promise you the second time will be much shorter. But if at any point during the course of this, someone needs a break, you can't hear something, you just need to stand up, please catch our attention. We will plan to take a break, but we want to make sure that if someone needs that earlier, you let us know, okay? So I have slides. Everybody processes information differently. Lots of you take notes. You can see that the attorneys take a lot of notes too. Some folks are much more auditory processors, and some folks are very visual processors. So I've tried to give you a number of different ways, as the court has during the course of this as well, of processing that information. If slides do not work for you, then please ignore them and don't pay attention to them. It helps me stay on track. It helps me present it in a more organized fashion, but that may not work for everyone else, okay? So don't feel like you have to pay attention just because they are there.
This is as loud as it gets, by the way. I put it up as loud as it gets. And if she just stands away from the microphone, I can't help that. But it is blasting 100% volume as much as I can.
There we go. So I always start with this first slide, lawyer statements. Lawyers talk a lot, right? That's what we do. You are going to hear, obviously, from the group of us. First myself, then Mr. Kading, then Mr. Leary, and then me again. What we tell you is not evidence. The evidence is the testimony and the exhibits that came from the individuals that were sitting in that seat over there. The attorneys will tell you things. We will argue to you the evidence we believe that you have heard over the course of the last several weeks. Attorneys are human too, and whether it is myself or Mr. Kading or Mr. Leary, what we tell you is not evidence. So if we misspeak, if we say something that we believe a witness has said or we recall a witness having said, and that does not jive with your memory of those events or your notes or your recollection, your memory, your notes is what the evidence is. We are not the triers of fact. We are just the attorneys, okay? So please rely on the instructions you've been given by the court and your recollection in those notes. So evaluation of the evidence. We provide this instruction also as well. Oftentimes you will hear folks during the course of whether it's a TV show or an argument or something else, well, it's just circumstantial evidence. It doesn't mean anything. That's an inaccurate statement. When you come in, at least in the state of Washington, when you come in here, you do not come in here in a vacuum of life experiences. We want a fair and impartial jury, both for the state and for the Alis. We want to ensure that that is what you are there to do, but we do not assume that you have no life experiences and you cannot process information about what is reasonable behavior, what is unreasonable behavior, and reasonable inferences to take from those. So in Washington, we give you that distinction between direct and circumstantial evidence. Direct evidence is that thing that you have directly perceived. Circumstantial evidence is the thing that you know and you can make a reasonable inference from. So let me give you an example of that. And we use a cake example very often, right? If you go in and you make a cake, everyone who's ever made a cake knows you cannot frost a hot cake, right? My bakers know that. That frosting is going to slide right off the side and be a gooey puddle. It will look nothing like what it's supposed to do. So if you make your cake, you have to let it sit out and cool. So now let's say that you've made that cake. It is sitting out, it is cooling, and you live alone, you live with your dog, and you have errands to run. So you lock your doors, your windows are all locked, nobody else is there. You come back a couple hours later, and what was once a beautiful cake waiting to be frosted is now in shambles on the floor. There's crumbs everywhere. Your dog looks comfortably full, and there's crumbs all over the dog's face. Direct evidence would have been a video watching your dog eat that cake. Circumstantial evidence is exactly what we've just described. You know your dog ate the cake. That is the only reasonable inference that comes from that evidence. You didn't see it, but you know that that's what happened. There's no other reasonable explanation. No one's broke in. You said no one lives there. There's no windows. That's what happened to your cake. That is circumstantial evidence. And that is in large part why we provide you this instruction, but we trust that you are going to use your rational mindset and your common experience to know what facts and inferences to take from the evidence that you see. There may be differences in types of evidence that you receive, but the fact that one is circumstantial and one is direct makes no difference in terms of the weight that you give it, just by definition. So please don't get stuck in that loop in deliberation, like, well, it was only circumstantial, or oh, it was direct, so that's better than this kind. That's not the case. Like I say, that individual piece of evidence may have a different weight, but that weight is not drawn from whether it is a piece of direct evidence or a piece of circumstantial evidence. Okay? So evaluation of the witness testimony. Our way through those. In addition to the fact that you are the triers of fact, the sole triers of fact, you are also the sole judges of credibility. The attorneys are not. We cannot comment on the credibility of witnesses. We can point out whether there was a particular manner about a witness testifying, whether there was a personal interest, whether there's a reasonableness of the statements that they may have provided to you in context of everything else that you saw, but you are the sole judges of credibility. So when you are looking at the testimony of witnesses and how to evaluate that, you are given an instruction about some of the things that you can look at to help assist you in that process, okay? Reasonable doubt. Before you came into trial, if you've never sat on a jury before, but before you came in here, I believe that you would probably describe yourself as reasonable people. Most people would describe themselves as reasonable people. Having sat in here now and gone through all of these instructions, I would submit to you that we have ruined you with the law. You are no longer reasonable people. When you go back home and you're talking to friends, when this is all over, or talking to your family, when the court has released you from your instructions not to talk about it, you can say, well, I don't know, I had a reasonable doubt that we didn't convict on A, B, and C, or at all because I had a reasonable doubt. Or we convicted them on A, B, and C, or we convicted them on all because we had an abiding belief in the truth of the charge. Nobody talks like that. Lawyers talk like that, right? But now you will talk like that, at least as you're evaluating this and in talking to each other in that back room. So what does reasonable doubt mean? And you have the instruction. I submit to you that reasonable doubt and abiding belief are two sides of the same coin. If you have an abiding belief, then you do not have a reasonable doubt as to the truth of the charge. An abiding belief is abiding, long-lasting. You believe it today, you believe it tomorrow, you believe it next week, next month, next year. That is an abiding belief in the truth of the charge, that the defendant did what the state has charged them with, and that the state has proven that beyond a reasonable doubt. You have an abiding belief. If you have a reasonable doubt, then you cannot have an abiding belief in that truth of that charge, right? So it is not, there's no numeric value that you can apply to it. It's not a 51% or a 75%. Reasonable doubt is one of the highest standards, certainly, that we have. And we talked about that during voir dire, but it is not 100% either. So there is no numeric value associated with reasonable doubt. But as it says, if you have an abiding belief in the truth of the charge, then you do not have a reasonable doubt. And it's just another way of, I think, talking about that and evaluating within yourself. It's kind of this, amorphous is not the right word, but we as humans really like objective measurements, and there's no objective measurement associated with reasonable doubt. So you really have to look at this standard as you're talking about it and thinking about it amongst yourselves, whether it has been achieved, okay? Things you will not get. The court told you this just now in the instructions. Ms. Zoe talked to you about it during opening arguments, or excuse me, opening statements, if you recall. You are not going to get certain documents. And that I know is frustrating every time for a jury because people have referenced them. But the reason that you don't get them is exactly what we talked about, because the testimony is the evidence. A police report is not evidence. If that were the case, we wouldn't call anyone into court. You wouldn't hear from witnesses ever. We'd have them write a statement, you'd have police reports, you'd get doctor's reports, and you would never have anyone come in and testify. In the law, we value the testimony of people who are coming to tell you what they saw, what they heard, what they observed, what happened related to these events. And that is why the testimony comes from the person sitting in that stand. That's why you don't get police reports that officers have made along the way. You're not getting medical reports because the doctors came and told you what is contained within those reports and told you what they observed. Prior statements of witnesses. You don't get those either, right? That's why we have cross-examination, why we have direct examination. So please don't ask for them because they are not coming. You have to make your decisions based on the information that you have heard and what you have received as exhibits. And as we go through this process,
True,
right,
Renee.
talking to each other. And then last, of course, transcripts of any trial testimony. You're not getting any transcripts of, can we get a transcript of what so-and-so said on such and such day? That's not coming either, okay? So as you are going through and organizing your thoughts, please keep that in mind. There's a lot of overlap. So I'm going to tell you that there is approximately, if I did my math right, 11 different crimes that I have to go through and describe to you. There's a lot of overlap in that evidence. So I've tried to break it down as we go through those crimes where there is a overlap between both parents, and then we'll separate out some of the parents. So let's start first with count number 1, attempted murder in the second degree of that victim, Fatima Ali, for both parents, Ihsan and Zahraa Ali. Attempted murder in the second degree. I think it's instruction 14, I believe, gives you what it looks like if there is a completed murder in the second degree. Please do not get caught up in that is what the state has to prove. That is not the case. Instruction 14 shows you what completed murder in the second degree would look like. Instruction number 15 tells you what attempted murder looks like. If they were to have done this and completed it, this is what the state would have to prove. Instruction 15, I believe, is the one that says that here are the actual elements that the state must prove, and that is a substantial step. A substantial step needs to occur. So a person commits the crime of attempted murder in the second degree with intent to commit that crime. He or she does any act that is a substantial step toward the commission of that crime. Okay. There is the completed murder in the second degree. A person commits the crime of murder in the second degree when, with intent to cause the death of another person, but without premeditation, he or she causes the death of such person. Then you are given what I'll call a bunch of definitional instructions. This one is as to the mental state. So intent, a person acts with intent or intentionally when acting with the objective or purpose to accomplish a result that constitutes a crime. Here's your definition for substantial step. A substantial step is conduct that strongly indicates a criminal purpose and that is more than mere preparation. It's not simply thought, but it is an act in furtherance of that intent. So these are what we talked about initially. The defendants are charged with attempted murder if, and I don't know that my red, it's a giant red dot. So you can see the if underneath, right? If the defendants were charged with a completed offense, this is what the state would have to prove, right? But because it is attempted, this is what the state actually has to prove. That on or about October 18th, the defendant did an act that was a substantial step toward the commission of murder in the second degree, that the act was done with the intent to commit murder in the second degree, and that any of these acts occurred in the state of Washington. And then when we talk about Zahraa Ali, the only difference between Ihsan and Zahraa is that Zahraa is charged as a principal or as an accomplice. Ihsan is only charged as a principal. Zahraa is charged in both fashions. So principal, you do it yourself without any help, or accomplice, that you were doing it to assist. You're assisting another in reaching their goal. So let's talk first about elements 1 and 3 for both parents. When we talk about elements 1 and 3, there's going to be, as I said, overlap. These are the elements that I anticipate there's not going to be a lot of argument from. I still have to prove them to you. The state still has, beyond a reasonable doubt, responsibility for proving these, but defense counsel, I don't believe, is likely to argue that it didn't happen on October 18th and it didn't happen in the state of Washington. So here's the evidence that applies for each of those, right? All testimony agrees that this was Friday, October 18th, 2024. You have the bus and the body cam videos that you saw that confirmed that. And then you have the testimony of the date and time of those school videos that Celeste Waltermeyer. we pull it and download it, those dates are not shown on that video, but that's specifically the date, time range that I was looking and pulling from. And that information that you see in context on those school videos themselves from Timberline High School are consistent with what you see in context from all of the other videos. So I submit that that's accurate. She didn't pull a different date or a different time.
I just want to say that talking about the jury instructions and closing arguments is always very important. It doesn't matter if you're the prosecution or the defense. You don't have to go through all the jury instructions, but the important ones you should talk about. It's a big mistake to ignore them and just argue your case. You want the jury to understand what the jury instructions are that were given by the judge and why your case, if you're the prosecutor, why you win. And for the defense, why the prosecution didn't prove their case. I mean, that's what you have to do. So what she's doing in terms of going over the jury instructions, explaining what the charges are, explaining what second-degree murder is, obviously, this is all very important. It's more of a question of style. When do you want to do it? How do you want to do it? Do you want to try to make it more exciting or less exciting? Whatever. I mean, but the fact that she's talking about jury instructions is always an important part of closing arguments.
Right. Element 3, that these acts occurred in the state of Washington. This is Timberline High School. That testimony occurred over and over again. 6120, Mullen Road, Southeast, Lacey, Washington. And all of that testimony confirms the same. You're going to see this, a variation of this slide, a number of times because it applies to every single count that we have, okay? So again, what exhibits do we have that demonstrate that as well? Here is exhibit 1. You have that bigger aerial photo. You have Timberline High School. You have the parking lot here. Now my red dot is covering towards the bottom center of that page where that bus stop is, and you have Mullen Road that runs diagonal across that page. Exhibit 2, bigger shot of the same thing. Again, at the bottom left corner, you have that bus stop identified. Mullen Road is identified. You can see that parking lot that we've watched several videos of throughout this trial. And you can see the crosswalk running diagonal across the parking lot, but almost directly perpendicular up and down on this page with the white dashes running across it just to the left of center. And that's the crosswalk that we observe Fatima and during the course walking to the bus stop, and then again, people describing later towards the Timberline High School, which is outside of this photo, but would be at the very top of it, right? That's where those front doors are. So then we talk about let's talk about the rest of element 1, right? Remember, element 1 under attempted murder has a couple of different things within that element itself it has to prove. So the rest of element 1, speaking first to Ihsan Ali did an act that was a substantial step toward the commission of murder in the second degree. So what evidence do you have of that? What facts did you hear during the course of this trial? First, you have it. He grabs Fatima by the hoodie and places her in a rear naked choke. Let's be clear, the state is not asserting that Ihsan Ali showed up on that day with the intent to try and kill his daughter. There was no premeditation that the state is asserting, but by the time Ihsan goes into these events, the state's position is that that has changed. His intent has substantively changed. He grabs her by the hoodie and he places her in a rear naked choke, and we've heard that described with specificity. He takes her to the ground. He holds her in that choke for an extended period of time. He ignores those repeated screams and demands of no less than 6 kids. There's probably more there at varying times, but there's approximately 6 that are there pretty consistently throughout that entire process, and 2 separate adults to release her. We see Mr. Denicola come up on the scene in his bright orange vest. We see later Josh Wagner arrive on scene, and they're all saying the same thing. They're all screaming at him to release her, to let her go. Denicola, I think even at one point, I submit when you watch that video, is pointing a finger, and he's telling you, he told you in his testimony, I was telling him to let her go, to release her, to let her go. And he was just doing nothing. He was ignoring me. So it's not just kids that are running around. There's no chaotic panic. These are adults that are watching it happen and very clearly know that this is wrong. They're screaming that she can't breathe and he's killing her. And you hear that on the video. He continues to hold her while she fights and struggles. There's an apparent seizure. She goes limp, and then she is unconscious. The testimony by everyone is that her eyes have rolled back in her head. Her face is pale. Her lips are blue. And I believe Josh Wagner says she has changed colors. When asked on direct examination, Mr. Wagner, based on what you observed, and you came to it towards the end, based on what you observed, is there any way that could have been confused with hugging or simply restraining that child? And his response is no, it's very obvious she was being choked. That was Josh Wagner's statement. And then you have exhibit 61, which is Elijah's video that shows you exactly the same thing. So I submit to you that that substantial step towards murder in the second degree has been taken. So then element 2, that the act was done with the intent to commit murder in the second degree. So what evidence have you heard throughout this trial that shows that? First, he holds her throughout all of that and continues to hold her after. The only time he releases her is when Josh to release her. All of these things are happening. This is not a like, oh gosh, it happened so fast, I had no idea what to do. It is an extended period of time, and he continues to hold her. Denicola, remember, he testifies that his arm is straining around her neck, that Ihsan's arm is clearly, there is a tension there. His hands are locked. Mr. Denicola's statement was, when asked, how do you know, what did that look like? And he was like, it was the look on his face. So he is there with them on the ground, and Ihsan's face clearly demonstrates to Mr. Denicola the intent behind what Ihsan Ali is doing to his child. It is so upsetting, in fact, Mr. Denicola testifies towards the end that he calls his supervisor to call it in, and he says he is in shock. He's trying to process what he just saw, and he has to pull the bus over on the side of the road, and his supervisor has to come take his route. That is how upsetting. This is not a group of kids that are just overreacting to a situation. That is how upsetting that event was to Mr. Denicola. And he's described, I have security camera on my bus. I've had to look for a bunch of things, fights, whatever. He had to pull his bus over to process what he saw here because it was so upsetting. So what does that tell you? How is this different from the objective observer that doesn't know any individuals from Adam about what he observed from Mr. Ali's intent, that it was an intent to commit murder, not something else. You have Caleb talks to you about what we're trying to get him off. In fact, I'm pulling so hard at his arms that he tears Ihsan's coat, and still he doesn't release. Nothing changes. And you see evidence of that coat tear later. It is shredded down his arm. Ihsan doesn't let go. He is holding on to Fatima's neck throughout. He releases only when he is physically forced to do so, despite, and go back and watch the video I submit to you, she has stopped struggling for approximately 15 to 18 seconds prior. She's unconscious, and he continues to strangle her around the neck for another 15 to 18 seconds, and would have continued to do so even longer, but for the intervention of those adults. Then you have Dr. Gilbert's testimony about the effects of strangulation on the body, what happens, and why that happens. She talked to you about the jugular vein inclusion, carotid artery inclusion, and tracheal inclusion. Remember, the lack of, starting first with jugular vein inclusion, the lack of removal of deoxygenated blood. Those are those thin-walled veins on the outside of your neck, right? You need the bad blood to come out of your brain so your brain can function. And we'll come back to the pressure, but it's about 4 pounds of pressure for that jugular vein inclusion, one on each side, thin walls. Then she talked about the lack of oxygenated blood to your brain. That is that carotid artery occlusion. Those are thicker walled arteries, and they are deeper within your neck, right? And that is greater pressure to close. She said about 11 pounds, I believe. And then she talks about what that lack of oxygen to the brain and that buildup of pressure does in the brain, how that leads to brain death, which is death. So then we talk about element number 1 for Zahraa as a principal or as an accomplice. So remember first, this is generally speaking what it means, that language principal or accomplice means. All assistance by words, acts, support, or presence. and present at the scene and ready to assist. First we have, well, let me back up for one moment. When we talk about principal or accomplice, it's really obvious what a principal is, right? You're the person doing it. You don't have any help. You're doing it sort of independently yourself. As an accomplice, if you're assisting someone else. And we distinguish, I'll give you a bank robbery as kind of the classic example. When we distinguish an accomplice in like a bank robbery identification, right? We want to talk about the people that are there to help assist the principal in doing whatever the principal is doing, generally robbing the bank. We want to distinguish that person from the customers that are present, that are there to do business. They know bank robbery is happening. They're present and they're aware, but certainly we wouldn't identify the customers as accomplices in that case. We would identify the getaway driver, the lookout, the other person who's providing the banking information or copies of the key. We would describe those people as accomplices. And even the lookout, right? They may not even actively touch anything. They may literally just stand at the door, but they are still identified as an accomplice. So that accomplice liability instruction, and you have it in your instructions. I don't recall the number off the top of my head, but that is what distinguishes somebody who's just present and has knowledge of what's going on from the person who is actively engaged in trying to fulfill the goal or extend the behaviors of the principal, right? All assistance by words, acts, support, or presence, and present at the scene and ready to assist. That is your accomplice liability instruction. So what do you have? You have Exhibit 34 at 2:13:57 on Exhibit 34, and that's that the bus video, the road view of that bus video. Mrs. Ali arrives at that tree. Josh Wagner, white line, he's still in the street on Mullen Road. Ihsan is struggling with Fatima, but Zahraa is already there. She is a couple steps ahead of Josh Wagner. 2 seconds later, same exhibit, you see that Zahraa is at the group. She is bent down with Fatima. Her arms are outstretched. Josh Wagner has just reached the dirt. He's not even at the group yet. So he's not there. He hasn't interrupted the strangling, but Zahraa is there, and Zahraa's not like somewhere else. Zahraa is right there. She is bent down with those individuals. These are separate acts and behaviors from those of the kids watching, because what are the kids doing? The kids are still screaming, get off of her, like go of her, you're killing her. And what does Mary Wagner say? Mary Wagner says, Zahraa is not helping the young woman on the ground. She seems to only be trying to stop the teens from hitting the man who is strangling Fatima. She did nothing to assist Fatima from what Mary Wagner saw. That's, I submit to you, what you see on the video. It's fast. Remember that those videos go, they pause, they go in slow motion, and you have access to those to fully and fairly consider that. But she goes in and she immediately is pushing kids, but she's not providing assistance to Fatima. Neither Josh Wagner or Denicola describe any assistance for dislodging Fatima by any other adults. They're the only two that are in there trying to get Ihsan Ali's arms pried off of the neck of his daughter. No one else in terms of adults are doing that. Then you have Exhibit 122 plus Mrs. Ali's statements. She clearly expresses over and over again to law enforcement that her concern is for the kids that are hitting and striking her husband, not Fatima. In fact, she doesn't even mention that her husband has been strangling Fatima. But she's there. We know she sees it. Everybody else sees it. But she says not a word about how her child has been strangled into unconsciousness. And we know by the time she arrives, Fatima is unconscious. She is pale, her lips are blue, and she is laying still because there's only about a handful of time from the time that she gets there to the time Josh Wagner is able to get Fatima released. And what does Josh Wagner say? He immediately knows that a child is being choked. He doesn't say, when I got up, I could see that it was a child being choked. When I got out of the car and started coming across the street, I could immediately see this is a child that is being strangled. Immediately. And again, he doesn't know these individuals from Adam, but Mrs. Ali does. In fact, she's outside of Isaiah, is really the only one who knows exactly who is strangling and who is being strangled. And she doesn't mention a word to law enforcement. Remember what Officer Bell says. When asked, how long until you knew? He was like, at the end. It was basically to the end of my time there on scene before I had any idea that Fatima had been strangled. Because even though I had talked to mom and had interactions with mom, she didn't say anything about it. Not a thing. So we have to go through the accomplice liability and the principal for Zahraa. So element 1, as an accomplice. What evidence do you have? As an accomplice, at 2:13:55 into that exhibit. And remember, that's the date time. In exhibit 34, it has the date time stamp on the bottom. So 2:13:55, Fatima goes unconscious. So we know she's already in that state by the time mom gets there. Her face is pale, her lips are blue. Ihsan is still actively strangling Fatima at that time. We said she knows what's going on because it's apparent to everyone else, immediately apparent to everyone else. And Zahraa is the only one that knows those individuals. And that she's attempting to intervene on behalf of her husband while he is still actively choking Fatima. Not Fatima. She's not attempting to intervene on behalf of Fatima. That is a substantial step. That is more than your presence and knowledge at that scene. We know that Fatima is not released by Ihsan until about 2:14, 10 to 13. So that if you look at that video and watch, somewhere between 10 seconds after and 13 seconds after, that is when we know Fatima gets released. So there's a period of about 11 to 14 seconds where mom is assisting Ihsan and not Fatima by trying to prevent assistance to Fatima from those kids. So again, as an accomplice, element 2 for Zahraa, that it was done with the intent to commit murder in the second degree, that she is actively watching her husband strangle her child in that rear naked choke with the arms tightly locked around her child's neck. She is actively able to see what every other person has described as Fatima's appearance throughout that time. She has time to view the situation and make a decision to try and remove impediments and prevent injuries to her husband. So we know she's able to quickly evaluate a situation and take actions based on her evaluations. To be clear, this is not a complicated fact pattern to evaluate when you have arrived on that scene. Everybody says so. Everyone that's present says so. Every other person immediately knows the danger, obvious danger of death to Fatima, but somehow mom doesn't. So what do we take from this? Her loyalty is to her husband and his purpose, not to her child. So then as a principal, what is the substantial step, the evidence you have of a mom as a principal? She's just watched her child being choked and unconscious for approximately 11 to 13, 14 seconds per that bus camera video. She is then, Fatima is then released. Josh Wagner gets her released. She is incoherent. Remember what Fatima says. The last thing she sees, remember seeing is Isaiah on her face and bushes. And the next thing she knows, she is in her mom's arms, and her mom has her arm around her neck. She is not there. Mary Wagner talks about that, like that girl is not there. Like, I don't have another way to describe that. She just was clearly not aware of what is happening around her. She has come out of that unconsciousness. But she immediately wraps her arms around Fatima's neck. Her ability to breathe, Fatima says, I can't breathe. I'm trying to tell my mom, but everyone describes like nothing is coming out. There's no sound coming out. Denicola says he remembers hearing her being almost like raspy, whispery, but she wasn't really making sound. And plainly he said, I wasn't looking at that. I saw what appeared would be a mom and the child, so I assumed they were fine. My focus is on dad because that's where the immediate threat was. and I was trying to pay attention to the immediate threat. But I remember hearing this very whispery, raspy. That is consistent with what Fatima told you that she was trying to do, trying to tell her mom, I can't breathe, I can't breathe. And her mom doesn't let her go. So what happens? Then the kids intervene as well. That's the substantial step. Dr. Gilbert, again, all of that same information about the effects of strangulation on the body and why. And certainly, if you've just been strangled for 45 seconds, being strangled a second time doesn't improve that condition. You don't start over from zero as if the first time it never happened. It is a continuation of that strangulation. So what is the information that the act was done with the intent to commit murder? Same intent as accomplice liability. That hasn't changed. She has actively watched her husband strangle her child. She's actively able to see what everyone else has described. She's had time to view that situation and make decisions to try and remove those impediments to her husband and prevent injuries. And she's had, at this point, when she is separately strangling her daughter, has even more time now, knows the danger, and does it anyway. She does it anyway. That is not an effort to comfort her child. Again, that is not where her loyalty lies in this situation. And she demonstrates that over and over and over again during the course of those videos. So here is that bus video. I'm going to play it in regular speed. You can play it whatever speed you want.
Oh, they're not showing it to us. I think a lot of people have already seen the video though. If you're joining us now, they're showing the video of what happened, but they're not showing it to us.
This is what you see from the backside, right? They've now run away. And this is the face of Isaiah. and Fatima as they are running to the school for help. It is not the face, I submit to you, of children who are just goofing off, who just believe that they are trying to get away from their parents because they're going to get in trouble. Evaluate what that face looks like as Fatima's running away from her parents. Look at Fatima's face when she comes in Exhibit 111, page 3 of that, because it comes in a packet of still shots. Look at Fatima's face when she comes in that office. You heard Tracy Arnold testify that she looked like she was in terror. She was frantic. Submit to you that is consistent with what Exhibit 111 presents. Now you also have a instruction with attached to a special verdict form. Everything that is a -1, essentially, in your packet. There's a lot of verdict forms, you guys. Everything that is a -1 is what we'll refer to as a special verdict form, and you have to just answer yes or no. And that is essentially depending on which count it is Ihsan a family or household member, or is Zahraa a family or household member of Fatima? And here's the instruction that describes what a family or household member is. It's exactly what you would think it is, right? If you are a biological or legal parent-child relationship. So in terms of the elements, attempted murder in the second degree, family or household member, on special verdict form A1, Ihsan Ali is Fatima's father. Everybody says so. Fatima says so, right? In fact, part of the defense that has been provided to you is that they are parents, they are her parents, and so therefore they get to behave in a particular way. So I submit to you, this is not an argument between the parties. You still have to find it, again, beyond a reasonable doubt. The parties are not arguing about whether Ihsan and Zahraa are Fatima's parents. So the answer, if you convict on any of those charges, the answer on each of them should be yes. So now we're going to jump over to count 3, unlawful imprisonment of Fatima, again, for both parents. Your Honor, it sounds like maybe we need a break.
All right, I'm going to ask the bailiffs to come forward, and we're going to take a recess for 10 minutes. Remember, you are hearing closing arguments, and deliberations has not begun. You are not to discuss anything during this break. We'll be in recess for 10 minutes.
All right. Well, I'm just trying to find some of the video here of the attack. I see some parts, but not a clear shot. Prosecutor so far, I mean, it's she's going through the evidence. She's going through the jury instructions and explaining how everything fits in and why there should be why they should be found guilty of the charges. So, very very methodically and carefully and slowly, and so she's getting there. It's just taking a while. So I mean, she could be doing things a little bit quicker. She could have been, trying to make it a little bit more exciting, but she's doing it. She's doing it. Okay. If I turn down my mic, if I keep my mic maybe a little bit further away from me, maybe that's better. But we have another few, I guess, a 10-minute break now, and then there's going to be a break for lunch. So she played the video. The video really speaks 1,000 words. I'm trying to find the video. See if I can find it. All right, I'll show you what I got here. Pretty graphic. So, I mean, this is from Court TV again, and from Vinnie Politan. But if you guys want to see it, I'm going to play it, and just viewer discretion is advised. That is what they just played in court, I'm assuming. So, all right, here we go. If you have kids around, get them out of the room. You can see all these people are trying to get him off of her. He's on the ground in this chokehold, and all these people are trying to get him off.
You see that man stepping up?
Well, there it is. See if we got more here.
Did you see it? Yeah, I saw the whole thing. That's the suspect or victim? That's the guy that was hitting the ground. Hey, God bless you. Hey, yeah.
He did. He was trying to kill us.
Hands behind your back. Hands behind your back now. You guys step back. Was there any other parts?
And if you're just joining us now, we're just on a little bit of a break of the closing arguments, and this is what they were showing to the jury. So we're just taking a look.
And my mom, she's right after her.
Stay back.
Get her.
Stay back.
I need to call.
Stay back.
She was
Stay
afraid
back.
too.
Please.
Now you need him over here.
Bring up the arms for that.
Hey, stand back.
I got the mail. Sick.
Dad, shut your mouth. No, listen.
He's the can by the bus stop. He's going to be the primary aggressor. At the moment, but I'm going to read you your rights, okay? So you have the right to remain silent. Anything you say.
All right, well, not exactly sure what any sort of defense is going to be here, but that's the video. All these people are trying to get him off, punching him. He's not getting off. That wasn't exactly a hug, have a great day in school. So that's not going to work. But yeah, let's get the closing arguments back up, although we're still on delay here. Whew. Pretty brutal. And as Lee says, the video says it all. Sure does. School was over for the day, so it wasn't so happy you're going to come back home with us. I mean, that's not exactly how you hug somebody. So I'm going to take a quick break, and I'll be right back with you guys. All right, let's keep moving with this 2-hour closing argument. I mean, really all she needs to do is play the video and say, okay, I rest my case. Do the right thing.
Please be seated. Ms. Stone, you may continue with your closing argument.
So now we've moved on to count 3. We're going to skip count 2 for Mr. Ali. We're going to come back to that. As you can see in your instructions, there's some other instructions that follow along with that. So let's skip over to count 3 first. That applies to both Ihsan and Zahraa, and that is the unlawful imprisonment of Fatima. So you have the instruction that tells you what unlawful imprisonment is, how unlawful imprisonment is defined. I've highlighted for you the intent element, which is knowingly. Person commits that crime when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty. If the restraint is without legal authority or without the person's consent, and the person knows that restraint is without legal authority and without the other person's consent. What is restraint? Restraint is without consent if it is accomplished by physical force, intimidation, or deception. You have that definition in your packet. I'll tell you, I don't recall what the number is. For those, I don't have them all committed to memory. And then you have knowledge. What knowledge is described for you. Throughout the course of your instructions, you have a number of different intent elements that are described for you, or mental states that are described for you. Knowledge, intention, doing something with intent, and as you'll see later, reckless. Okay? A person acts knowingly when he or she is aware of that fact, circumstance, or result. You don't have to know that the thing you're doing is a crime by NRCW. You have to know that the thing you are doing is the thing that you are doing. You're acting with knowledge that you are doing the act. If I walked over here and pushed Miss Zoe, I don't have to know that that is a particular type of an assault. I have to know that I am pushing Miss Zoe, right? If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. And when acting knowingly as to an element is required to establish the element of the crime, that element is also established if that person acts intentionally. So if I walked over here and shoved Miss Zoe, I know that I have to know that I've shoved her, right? Not like I tripped or somebody bumped into me and I had no idea that I actually bumped her or pushed her at the same time. If I walked up and 2 hands shoved her, if you agreed that I did that intentionally, then you also agree that I've done that knowingly. Intentionally is essentially one mental element higher than knowingly. So as it pertains to Ihsan Ali, that is your to convict instruction, count 3. You have that in your packet. We're going to come back to these. And then you have the same instruction for Zahraa, exactly the same, except again, it has for Zahraa that principal or accomplice language. That is the only difference between those 2 instructions in your packet, okay? So again, those elements as it applies to both parents. Remember, I said that we are going to talk about what overlaps between them first. So what applies for both, don't anticipate that there is going to be an objection, or not an objection, a disagreement by defense counsel that happened on October 18th, 2024. I also don't anticipate that there is going to be a disagreement. Again, you still have to find that I have proven it to you, but that the defendant knowingly, and as to this element, restrained the movements of Fatima in a manner that substantially interfered with her liberty. You have to find it, but I don't think the parties disagree that Fatima's movements were restrained. Ihsan strangles Fatima. She's unable to get away without help. Zahraa holds on to Fatima after, strangles her, would not let her go. Again, Fatima is unable to get away without assistance. So I submit that these are not going to be issues that are going to be really in contention between the parties. That restraint, as it relates to both parents, that restraint was without Fatima's consent. That is the testimony of everyone. She is fleeing her house and her parents. She has run away. She has been actively avoiding her family all day. Exhibit 34, you see that she is trying to run from dad. She is fighting dad. You have exhibits 74, 75, 78, 77, 81. You see all of those injury photos, and we're going to look at them in a little bit, but they show all those scratch marks to her neck. And you heard the testimony. I believe it was Dr. Gilbert. It may have been Lisa Wall talking about she's clawing at dad's arms, and you hear all of the students talk about that. Clawing at dad's arms, trying to get him off of her neck. Clearly, that demonstrates a lack of consent by Fatima to be restrained, let alone restrained in that fashion. And then Fatima tells you too, she's trying to tell her mom to let her go. She is not consenting to her mom strangling her. She is not consenting to the manner in which her mom holds her. And I want to be clear, we're going to come back to it, or not come back to it. We're going to get to it in a little bit because you have a parental discipline statute. The state is not asserting that a parent cannot restrain their child. We know that that is the case, right? There are things that parents have to do to correct restrained children, but this is not one of them. So as you're starting with the initial baseline of whether this happens with Fatima's consent, it certainly does not. And you have ample evidence of that fact. And then you have exhibit. Mom is strangling Fatima around the neck at about 2 seconds in, grabs her again at about 8 seconds in. You have those screenshots. It's far away. It is harder to see, I would submit, but it is there. The location of mom's arms. You have that Fatima, you see her forward, and then you have her leg going up, and you see that she is being pulled backwards at about 6 seconds in. She is trying to get away. She is looking to Isaiah for help. Her balance is being pulled off, and that is mom who is holding her at that point in Noah's video. Again, that applies to both parents, that the defendant knew that restraint was without Fatima's consent. That's the testimony of everyone. Her parents know that she does not want to be restrained by them, certainly. And all of that evidence is exactly the same. Not only was it without her consent, but that same evidence tells the parents that they know that it is without her consent. They're not under the mistaken belief that somehow she's okay with it, and that any of these acts occurred in the state of Washington. Same information that you had previously. Okay? So what is the unlawful imprisonment as it relates to element 4 only for Ihsan? First and foremost, without legal authority. You cannot strangle your child to restrain them. It seems really obvious, but apparently it has to be spelled out. You cannot strangle your child to restrain them. Instruction 21 is the self-defense instruction for assault, but I submit to you it is instructive for explaining the limitation on parents' rights for either correcting or restraining your child. You forfeit your right to use parental discipline to restrain your child when you do so in this manner, when you strangle your child and impede their breathing. It should be obvious. The other examples given in that instruction, you can't burn your child, that should be obvious to correct them or restrain them. You can't throw your child. You can't cut your child. You can't punch your child with a closed fist. Those should be really obvious things as parents, right? You do not, that force is incompatible with the duty to care for your child as a parent. So you cannot restrain your child by strangling them and cutting off their air. That is not an appropriate use of legal authority. And element 5, as it relates to Ihsan, that the defendant knew that restraint is without legal authority. He knows he's not allowed to strangle his child. You go back to that instruction 32, knowledge, subjective and objective components to knowledge. There's a subjective, he knows all the facts that what he is doing is not simply restraining her movements, right? It says, based on the facts and circumstances known to the person at the time, he knows he is not merely restraining her movements. Everybody there says it too, right? They're watching it. It's his arms around Fatima's neck. That objective measurement, if a reasonable person in the same situation would believe that fact to exist, then you are permitted but not required to find that he acted with knowledge. A reasonable person, I submit to you, with all of those same facts and circumstances known to Ihsan at the time, knew that restraining her in that manner was not with legal authority. There's no good faith belief here that such use is reasonable or moderate. And the law does not require you to know that that act is unlawful specifically or an element of a crime. It doesn't require you to go to an RCW or a jury instruction element 5 and say, well, I didn't know it was that element, so therefore you can't hold me accountable. That would be absurd, right? You have to know that the behavior itself is wrong and without legal authority. So how does that apply then to Zahraa? Again, same information. You can't strangle your child to restrain them. She watches Fatima being strangled by Ihsan. She then puts her own arms around Fatima's neck. She's not comforting her. She is strangling her to keep her from fleeing. Her breath is impeded. Fatima's breath is impeded by that hold. She testifies to that and told the medical professionals, you heard that from the professionals specifically, that she reported that by her mom to the medical professionals. You look at that instruction 21 and those limitations on what parents can do to their children to discipline or restrain them. She's doing it both herself as the principal, and she's continuing her husband's actions for that same purpose as an accomplice. That the defendant knew that restraint was without legal authority. That information is the same as it was for Ihsan. And then again, how do you know that she knows that that's without legal authority? Her own statements. Her statements are about how people have treated Ihsan at the scene. She has talked about, where is my daughter? Give my daughter back. I want to see my daughter. And I want to see my daughter. I want to talk to my daughter. Right? Her focus consistently is on Ihsan. It's not on the health or care of her daughter. Just location and access to her. That is all she expresses to law enforcement. So same thing, family or household member. This is your verdict form, C1. No change to that. Exactly the same as the last one. So now we're going to go to Ihsan Ali, count 2. And now that's the overlap between the two parents. Now we go to separate crimes for each of the parents. And we're going to start with count 2 for Ihsan Ali. That is that assault in the first degree. Assault in the first degree, the crime of assault with intent to inflict great bodily harm. He or she assaults another by any force or means likely to produce great bodily harm or death. And then you have the definition of assault. We'll come back to that. That will apply when we get to the assault on Isaiah. Touching or striking, harmful or offensive. Right? Great bodily harm. And great bodily harm that creates a probability of death. Bodily injury that creates a probability of death or significant permanent disfigurement or causes significant permanent loss or impairment of the function of any bodily part or organ, right? If you take somebody's eye, you're talking about great bodily harm as an example. Or if you use a measure of force that creates the probability of death if that force has not been otherwise interrupted. And that's what we're focusing on in this case. So you have those definitions, or excuse me, you have the overall elements. You're given that in your packet. There's 4 elements. So let's go through them. Well, we're going to talk about this first, actually. Physical discipline of a child that the force used was lawful as defined. We just kind of went through that. That force is lawful when it is reasonable and moderate, when it is inflicted by a parent for purposes of restraining or correcting. And you must determine whether the force used, when viewed objectively as a reasonable person looking at that same force, is that force reasonable and moderate? And that definition goes on, as I said, things that the law identifies as that you may consider unreasonable. Striking a child with a closed fist, interfering with a child's breathing. The other examples we talked about: burning, throwing a child, kicking a child, all of those things. As part of your determination of whether force used was reasonable or moderate, you shall consider the size, age, condition of the child, the location of the injury. Certainly, the smaller the person, the younger the child, the more concern there is for how that force is used on that child. It's not a binding inference, right? But that is an example of things that you can determine are. So that element, as it pertains to Ihsan, again, the things that I submit to you are not going to be in contention between the parties, right? October 18th, it's Fatima Ali and State of Washington. Those are not facts that people I submit are going to be arguing with you. Element 2 is where I think you're going to be focusing the majority of your discussion in this case as to this issue. So let's talk about the evidence that you have. Element 2, that it's committed by a force or means likely to produce great bodily harm or death. So first you heard from Lisa Wall, and you're going to see LOC because I run out of room in each of these, right? Loss of consciousness. What happens when you lose consciousness? Your muscles relax, the damage becomes easier to inflict, and the easier the damage is to inflict, the result is death. That is the next logical step following loss of consciousness, is death in that process. You have the exhibits from Synovia Rivas, 67 through 81. She talks about the symptoms that she observed immediately afterward during that exam: headache, dizziness, lightheadedness, again, loss of consciousness, memory loss, a fuzzy feeling. Fatima reported feeling fuzzy, confusion, weakness and numbness, vision changes. She says everything got dark. You heard her talk about that. Hearing changes. She had ringing in her ears. She had neck pain, external neck pain. And you see all the bruising from that. You hear her talk about her sore throat, her difficulty and pain swallowing, those voice changes, the hoarseness. They describe her as hyperventilating. She was still hyperventilating after the fact. All the redness, abrasions, and bruising, and then the petechia around the eye that she describes. Fatima described a 5 out of 5 for pain, told Ms. Rivas she thought she was going to die, and it felt like it went on for 5 minutes. It felt really long. She said, I'm sure it wasn't. I know it wasn't, but it felt really long from where she was. And think about what Dr. Gilbert, when Dr. Gilbert went through and talked to you about what the effects were of jugular vein occlusion, carotid artery occlusion, tracheal occlusion. She correlated all of that to those symptoms specifically. Why do you get headaches? Because you have that buildup of pressure, right, in your brain. Why do you have loss of consciousness? Because there's not oxygen going to the brain, right? There's not bad blood coming out. There's not good blood going in. Why do you have memory loss or fuzzy feeling? Because all of that brain function has been interrupted as that process goes. She talked about the eye changes and the hearing changes because your brain stem is interrupted, and the ability for your brain stem to process and connect to the vision in the eyes is been interrupted and is unable to do so. Hyperventilating, we talked about panic. One of the natural symptoms, your body's natural reaction is to panic when it can't breathe, and that panic continues on until it no longer feels like it is in threat or fear. She's describing hyperventilating to Synovia Rivas while she's arriving at the hospital, still after the fact. She has not come down yet. Her brain has not taken that threat away so that her breathing has returned back to normal. Dr. Gilbert talked about all of those things. So then you heard also by the force or means likely to produce great bodily harm, you heard from Dr. Kim, who was not excited to testify, right? He talked about that. It was terrifying for him. But an otolaryngologist, I'm sure I am mispronouncing that. He's a specialist at that point, called in by St. Pete's, right? Strangulation can result in death. This seems to be a very accepted premise. Strangulation can result in death, not one really for argument. He says that there's air in the esophagus. They didn't scope it because they were worried that there was a tear in the esophagus, so they're not going to put a scope down there and increase that danger. That air is from damage to the throat, not from compression to the chest, not because she fell down and people landed on her. That's not where that happens. That happens below. And the air that he saw was higher up in the throat area. So it's better in 24 hours, but he can't say it's gone. Remember what he said, like, it had not gotten worse. It wasn't gone. And he can't say it's gone because we don't do that kind of exam for that. We don't want to put that much radiation into this very small 17-year-old. Dr. Stankus is an ER doctor. She testified for the defense. She said pneumomediastinum. She agreed. It can certainly result from strangulation. She agrees that the standard of care for pneumomediastinum, the air that was higher up in the chest, to admit the hospital for observation and retesting, we don't send those folks home, right? It's not benign. It's not a mole. That was her example of something benign. We don't send those folks home. If you present with pneumomediastinum, especially as the result of strangulation, you're getting admitted, and we're going to watch you because it absolutely is dangerous. And Dr. Kim said, I had significant concerns. We were worried about her. That's why we admitted her. And Dr. Stankus agrees. Strangulation can result in death. Then you have Dr. Gilbert's testimony, and she talked about being a child abuse specialist and a 30-year medical practice. And she gave all of those strangulation effects on the body that we've previously talked about. She talked about that jugular vein occlusion. Remember, 4 pounds. That's that lack of ability to remove the deoxygenated blood. 4 pounds of pressure. It takes about a minute to lose consciousness with jugular vein occlusion only. 20 to 30 seconds for petechia, 3 to 4 minutes for death, if there is only jugular vein occlusion. Carotid artery occlusion, slightly different. Greater pressure required for carotid artery occlusion. 11 pounds of pressure, you lose consciousness in 20 to 30 seconds. Death is anywhere from 1 to 3 minutes. It's a range, right? You can't say specifically, but it's a range. And she talks about that. She said when a carotid artery occlusion, you're going to see more global results. You're going to see loss of consciousness. You may see seizures. Then you move to brain death or death and a loss of muscle tone. When Dr. Gilbert watches that video, she says, I believe that I see a seizure. There's a moment right after or right before she loses consciousness that her arms, I believe she says, flail without any movement. And prior to that, there's some significantly focused intentional movement. And then there's a moment of flailing, and then she goes limp. Fatima goes limp. Caleb says, that's the word he uses. Isaiah used, she frizzed, and then she went limp. So what are those kids describing to you? They're describing a difference between the moments where she is fighting, Fatima is fighting for her life, right before she loses consciousness. And I submit to you that is a seizure. And that is what Dr. Gilbert watches that video and believes she sees. She said, we can't test for it. That's not the kind of testing that we're able to do, but I submit that's what I see. And that is consistent with what the science says. It's consistent with what the witnesses observe. So how do we know that we've gotten to the carotid artery occlusion? Because about 30 seconds in that 20 to 30 second range, when you watch the video, that is when Fatima loses consciousness. So we know we don't have solely jugular occlusion. We also have carotid artery occlusion. He is imposing enough force on that child's neck to create significant damage, great bodily harm, and the likelihood of death, but for the interruption. And that death can happen in 1 to 3 minutes. Tracheal occlusion results in the lack of oxygen to the brain, that buildup of pressure. And again, Dr. Gilbert describes there's going to be immediate panic. You've got that CO2 buildup that's telling your brain that you have to breathe, and then it results in death. She describes observing the pneumomediastinum, the subcutaneous emphysema, that air in the throat, and anytime there's obstruction of either blood or air to the brain, it is a life-threatening injury. So Exhibit 72 and 103, the petechia described, you have synovia brevis on the left-hand side, and how do you know that it's petechia? Because it doesn't exist a couple of days later. 3 days later, it has resolved itself in Exhibit 103, and that is the distinction right between those two. October 21st, the photos show the bruising and scratches that cover from the left to the right side of her neck, consistent with the arm placement and pressure for her carotid artery, her jugular vein, and that tracheal occlusion. And you see that all in that space right there. Again, Exhibit 74, same, these are 3 days later. The bruising and the scratch is consistent to the front of her neck, where Fatima is scratching and clawing at her dad's arm to get it off of the front of her neck. That's the tracheal occlusion happening there at the front. Remember, your carotid and your jugular are on the side, and your trachea runs right down the center. Exhibit 81, the side of her neck, and that bruising goes all the way over to the back side of her neck. Again, consistent with the arm hold that is described by all of the witnesses leading up to that point, right? All of this bruising is the result of that, and that right arm and left hand in a chokehold from behind, and pressure for the carotid artery and jugular vein occlusion. So then element 2, again, force or means to produce bodily harm or death. Those symptoms reported in that video evidence tells us, based on the time and those symptoms experienced, that all 3 of those occurred in this case, which means the amount of time it takes to inflict the probability of death is grossly shorter.
I think we all can use a little break now, so I'll just read this from Blessed Mom in Texas. Love all your insight, BC. You have taught me a lot. Your brother there as well. Sending love to you and yours. Also, I need a civil lawyer. You need a civil lawyer. Need a civil lawyer. Well, you know how to reach us if you need a civil lawyer. Hope everything's all right, but thank you very much for that.
Force used would have resulted in great bodily harm or death if not interrupted. No injuries to her head are noted by medical staff or reported by her. Defense counsel, I believe in its cross-examination, said, well, if they hit that tree, couldn't this have happened? Couldn't this have happened? What if all of those symptoms are consistent with a head bump? And Dr. Gilbert said, some of them are. Not all of them, no, but some of them are. But also, I did a head to toe in none of those. There's no bumps on her head. There's no bruising. There's no tenderness. And there's no medical symptoms or science to indicate in any way that she struck her head. All of her injuries and damage is to her neck. All of the symptoms she experienced flow directly from that damage. And that's it. Element 3, acted with the intent to inflict great bodily harm. He's acting in anger for her defiance. That is intentional. That is what Ihsan Ali is doing. He holds her in a rear naked choke for just under a minute, and he is squeezing hard. He knows she is fighting. He knows she is struggling. He knows she is gasping for air. He knows that she is grabbing at his arms. And then she goes limp and stops fighting. But despite that, he continues to strangle her. So you know he is acting with that intent. He's ignoring the strikes and the screams of the kids. They are punching, they are kicking. It has zero effect. It does not impact or change his behavior in any way. And that is an extended period of time. You know that he already has his arms, in fact, around her neck when they go down to the ground, and he doesn't throw his arms out to catch himself. He's going down with her, and he's going to hold on to her neck no matter what happens to her in that process, from the beginning to the end. Because at the point that he grabs her by the neck, he is furious. And that is what he's acting with the intent with. It's not to restrain her. It's not to do any of those things. He is now just a grown man strangling a child. because he is angry that she has defied him. He's only released Fatima when he is forced to do so by other adults. When you go back to that family household member, that is your B1, that special verdict form again, nothing has changed. Back to physical discipline, that force used is lawful as defined, reasonable and moderate, purpose of restraining or correcting, and viewed objectively. So why does this not apply? Well, it applies for charged and lesser offenses. You're going to see that, and you have a whole range of instructions in there about lesser offenses. First, it must be your child. Okay, he meets that. It's his child. It's not somebody else's child. Must be for the purpose of restraining or correcting. It fails immediately there. None of this contact at this point for the assault in the first degree is for restraining or correcting. It is punishment. He's intending it for punishment of his child. Ihsan is angry. He may have gone to the bus stop to get Fatima and take her home, but by the time he grabs her, he is no longer doing that for the purpose of correcting her. I think one of the primary tenets of parenting is that if you are so angry you can't see straight, you do not engage with your child. You walk away. You don't attempt restraint. You don't attempt correction because you are no longer acting in a manner that is for the child's purpose. By the time you make contact with that child, you are doing so for your own edification. That's exactly what is happening here. Parents don't correct children by strangling them. Parents don't correct children, restrain children by strangling them.
No, you don't.
It has to be objectively reasonable and moderate. You are.
Yeah, in case you have children, don't strangle them. That's not a good way to teach them right from wrong by strangling them. So the prosecutor wants to make that clear here to the jury. Obviously strangling is not exactly the best form of teaching or discipline.
Seem to be reasonable people. That's why you're sitting here. It has to be objectively reasonable and moderate use of force, and that is not what occurs in this case. It is unreasonable to strike a child with a closed fist or interfere with their breathing. The medical evidence proves that his acts interfered with her breathing. You have to consider the size, age, and condition. We heard that Fatima's 5'1", 100 pounds, maybe soaking wet. She's a small person. She might be 17 years old, but she's a small 17. And she is certainly grossly smaller than her father. We also heard the testimony of Tracy Arnold. They have heard. Remember, Fatima's been home being online. She's not been at school since about September 17th, so they haven't seen her in about a month. And Tracy Arnold, she looked thinner, way thinner than the last time I saw her, and much more frail. So I submit to you that Fatima is particularly vulnerable. She already was with her size, but even now more so than she was just 4 weeks prior. And we also know that Fatima's throat is particularly vulnerable as a child. And Dr. Stinkus' testimony on behalf of defense also said, yeah, I mean, children obviously are smaller. It's easier to do damage to their windpipes. It's easier to do damage to their necks. She might be 17 again, but she is a small 17. And as a child, she is already more vulnerable than, say, an adult male, right? That placement of that force is extremely dangerous for those jugular veins, the carotid arteries, the trachea, and the spinal cord in the back of the neck. And all of the medical folks talked about that. You have an instruction in there that is very wordy, because again, we're lawyers and that's how we put things in a narrative. But I'm giving you a picture, okay? You start with assault in the first degree. That is what you evaluate first. You do not move on to any other instruction and evaluate it until you have completed assault in the first degree. If you have evaluated and deliberated on assault in the first degree and you agree unanimously that he is guilty of assault in the first degree, you stop. You don't address assault 2, you don't address assault 4, you stop. Your inquiry is done. If you're like, man, I don't know, then on assault 1, then you move over. Whether it's unanimously not guilty or you're unable to reach a verdict, then you go to assault 2 and you start that process over again. I will tell you that as you go through, you may well say to yourself, these two are easy, these two are really obvious. We'll just do those instead. You don't get to. Your instruction says you do assault 1 all the way first, and then if you are unable to complete that, then you move to the other 2. You work your way down, right? But otherwise, your inquiry stops if you all agree unanimously that he is guilty of assault in the first degree. Same thing. Do not begin that analysis until you've reached a decision on assault in the first degree. So then we go to assault in the second degree, that lesser included. When someone intentionally assaults, as it relates to Ihsan, when the defendant intentionally assaults another and thereby recklessly inflicts substantial bodily harm or assaults another by strangulation. You now have the definition of reckless, knows of and disregards a substantial risk, and that disregarding is a gross deviation from conduct a reasonable person would exercise in the same situation. I'm going to show you a ladder here, that mental elements ladder. So remember, we talked about if you do something intentionally, then you've done it knowingly. If you've done it knowingly, then you've done it recklessly. So it's a when recklessness as to a particular fact is required to establish element, it is also established if a person acts intentionally or knowingly as to that fact, right? And that makes sense, because if somebody has disregarded a standard of behavior that is expected, and that is a gross deviation, then we presume that you did so knowingly. I'm sorry, if you've done so intentionally and knowingly, then we presume that you've also done so recklessly, right? It's incorporated therein. So substantial bodily harm, a temporary but substantial loss or impairment of any bodily part or function, or a fracture. And then you have the definition of strangulation: to compress a person's neck, obstruct the person's blood flow or ability to breathe, or do so with the intent to obstruct the person's blood flow or ability to breathe. It's a really obvious, I submit, definition, but we have to give it to you anyway. So count 2, assault in the second degree. These are your definitions. We'll come back to the bottom paragraph, but you essentially have to decide A or B, 1A or B, and you don't have to be unanimous about 1A. So as it applies, same information for October 18th, 2024 in the state of Washington. None of that has changed. So 1A, intentionally assaulted. There are 2 ways that you can, Ihsan Ali could have done this under the assault in the second degree. 1A, he intentionally assaulted and thereby recklessly inflicted a substantial bodily harm. So the evidence you have of the intentionally grabs her twice. This is not an accident. He grabs her the first time and then he grabs her the second time. That moves into that rear naked choke with sustained pressure. Kids are pulling so hard that they have to dislodge him, that they have ripped his jacket. And regardless, he maintains his hold throughout. That is intentionality. Can't breathe is a temporary but substantial impairment. Losing consciousness is a temporary but substantial impairment of any organ or function. If you cannot breathe, if you have cut off air to the jugular veins and the carotid artery, or excuse me, blood flow, jugular veins and carotid artery, you have temporarily but substantially impaired their ability to function the way that they are supposed to. If you have cut off the airflow because you've crushed the trachea or closed the trachea off so the air can't get through, that is a temporary but substantial impairment because that bodily organ cannot function. If you have lost consciousness, your brain is not working the way it is supposed to. It is a temporary, even if you regain it, but substantial impairment because you are intended to stay conscious. That is what your brain is supposed to do, and his behaviors have impacted her ability to do so. Sore pain, sore, painful throat, difficulty swallowing, that she describes well after the fact, temporary but substantial impairment, those changes to her voice, those changes to her motor skills, her ability to get up and move around. You heard that described, that loss of muscle tone, temporary but substantial impairment. And then you have all of that bruising along her neck. By definition, that is temporary but substantial disfigurement. That is not how she appeared prior.
Okay, everybody, wake up. Now, just want to take this question. Before YouTube, Brother Counsel, how often did you watch / listen to full trials? Well, if they weren't cases that I was actively working on, the answer to that would be 0. I was working, and when I'd be watching trials, it would be for that purpose, or I was learning how to be a lawyer, and that's why I was watching trials, either as a law clerk or I clerked for a judge, watch his trials. But now that I'm doing this, so I'm watching more trials, which I enjoy doing. It's just I didn't have time before. So now I'm watching and listening to full trials. Now back to the action.
2, and we're looking at 3 days later, and it's scratches and that bruising is still there, those abrasions. So then strangulation, 1B, Exhibit 34. You see him grabs at her neck twice. It's not an accident and refuses to release. You see, again, that sustained pressure. A lot of that information is the same for strangulation as it was for 1A. You have that her face changes color. You have all of that bruising. You have the medical reports and the nurse's testimony. And you have that she can't breathe. Again, doctor reports, nurse testimony, and medical reports. So all that information is the same for 1B. Going to consistently have overlap in the evidence between many of your charges. When you go to do that evaluation, you have to all unanimously agree that either 1A or 1B occurred. You do not have to agree which of 1A or 1B it is to find that element number 1 has been met beyond a reasonable doubt. Okay? And then BB1, family household member, again, exactly the same. When we talk about count 2, as it separates itself, the lesser included for assault in the second degree from assault in the first degree, the initial placement of dad's arms around his daughter's neck and the impediment to her breath, that strangulation is complete. That's it. Assault second is done. As soon as he puts his arms, there's no requirement for loss of consciousness. There's no requirement for any of these other things to do. For strangulation, all he has to do is impede her breath. And the moment he puts his arms around her neck and you see her standing there grabbing at them before they've even gone to the ground, assault in the second degree is completed. That extended hold of her neck is what distinguishes assault in the first degree from that assault in the second degree. That is why that is not merely assault in the second degree. It is also, but it is not merely. So that's where we were. Back to your roadmap again. If for some reason you're stuck on assault in the second degree, then you go back through that same process. If it's guilty, you stop. If it's not guilty, unanimously, or you are unable to reach a unanimous verdict as to assault 2, then you go to assault in the fourth degree. So there's that definition for assault in the fourth degree. It's simply committing an assault. No bodily injury required whatsoever. Nothing changes for counts 1 and elements 1 and 2. And the back half of element 1 then, as it relates to Ihsan, simply that he assaulted Fatima Ali. The touching is harmful. We have all of that testimony of the parents, of those present, the kids, Mr. Denicola, the Wagners, all of the doctor and the medical. And then we have that the touching of Fatima is offensive. She's fighting it. She clearly doesn't want to be touched like that, like how he is touching her. There's no injury required for assault in the fourth degree. So yes, obviously assault in the fourth degree has been met by the evidence before you. And then BBB 1, that's your family household special verdict form again. And that's where you end up. So last count for dad, assault in the fourth degree as it relates to Isaiah. That definition is, we talked about those elements. They are exactly the same as that lesser included was for Fatima, but now it is for Isaiah. We all are likely to agree that none of this information has changed and it's not at issue in this case. It is October 18th. That is Isaiah Washington. So what evidence do you have about the assault 4 of Isaiah? That touching of Isaiah is harmful. You have the video of Ihsan punching Isaiah earlier in Exhibit 34. You have those still shots from Exhibits 8 and 9, 8 and 9 of him punching Isaiah in the head. Not simply a shove, not simply a push, but a closed fist punch to the side of Isaiah's temple. And then you have the Exhibits 39 to 51 showing his injuries, that redness, the bump, the pain. You have Officer Beltran described seeing that in person and taking those photos. And you have that testimony. And also, you saw Isaiah. It's physically much, much smaller than Ihsan. And you saw him when he was present here, and you see him in the video. They are not the same size individuals, right? And you know that touching is offensive. First of all, I submit to you punching anyone in the head, unless you are engaged in a boxing match, which you've signed up for, is offensive, right? Punching a child in the head is particularly offensive. Notably, no injury is required, but it exists here. There is that bump, that redness, and that swelling and that bump to the side of Isaiah's head. And you see it there, consistent with where he says he is struck and with where you see Exhibit 51, that closed fist strikes him in that bus video. So then you also have the self-defense instruction that is given to you for Ihsan, saying, well, I'm forced essentially to do this, and the state has to disprove that. So as it relates to count 4, force used by a person who reasonably believes he is about to be injured and the force he uses is not more than necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of those facts and circumstances known to the person at the time of and prior to the incident. Then you have a definition for necessary, as they reasonably appeared to the actor at the time, not as he claims that they appeared or he'd like them to have been, but as they actually reasonably appeared, that there's no reasonable effective alternative to the use of force and that the amount of force used was reasonable. And you have that in your definition. There's no duty to retreat, to be very clear. If somebody is attacking you, you are not required to retreat. But still, there's the requirement that the lawful force be not more than is necessary. You don't get to do whatever you want, plainly. There are limitations on what force you get to use in response. You also cannot be the person that physically instigates that interaction in order to create the likelihood of provoking a belligerent response from someone so that then you can use self-defense after the fact. And you have that instruction there as well. So why is this not self-defense? Start first, that force is not lawful. He does not reasonably believe that he is about to be injured when he strikes Isaiah. He is not striking Isaiah to himself. That's not what he is doing. And you'll look at those photos and you'll look at that video again. He is striking Isaiah to prevent Isaiah from interfering any further in his mind with what he gets to do to Fatima. It is objectively unreasonable what he does to Isaiah. He is grabbed at the point that a strike hits. Watch that video. He has already grabbed Fatima by the hoodie and he is dragging her by her neck into the dirt. And Isaiah's trying to pull him off. Isaiah's not striking him. Isaiah's literally trying to disengage Fatima from her dad, who has her by her hoodie front collar and is pulling her forward. It is already choking. That has already started. That is an unreasonable means of restraining your child. I submit. And Isaiah said, just like grab her, like, let's go home. That's not what happens. He's like, he grabs her aggressively. And remember that Isaiah has known Fatima at this point for a couple of years. And he says, I know Fatima.
How can this woman tighten up the closing a little bit? Well, she's got to come to my university.
Let's go home and have a
Brother Counsel University.
Concerned deeply.
And this is what we teach, trial advocacy.
To Fatima. And almost immediately, when she's getting ready to go, Dad grabs her by that hoodie and starts dragging her. And Fatima says that. It is, as we saw from the parental discipline, our laws recognize that it is objectively unreasonable to throw, strangle, or punch their own children with a closed fist, let alone someone else's child. And that's when we give more leeway to parents, right? If you look at that video, he's not striking, Isaiah is not striking Ihsan. The evidence does not support that finding. And we talked about the size of Ihsan compared to a 16-year-old.
Hey guys, let's just leave her alone, okay?
5'5". He didn't know how much he weighed, but I submit to you, he's a pretty thin kid. He's not a big kid. And he's also not punching a grown man who is in the middle of throwing.
ECU, Brother Counsel University.
That force used by any objective standard is unreasonable. You heard Elijah just thunk. It's like, I heard that thunk when it hit. He's punching Isaiah in the head with a closed fist. It's not okay to do that, especially not when and how that punch occurs. It's for the purpose of neutralizing Isaiah and get to Fatima. It's not for protecting himself. It's not self-defense. Ihsan has created this situation. Isaiah did not. Ihsan's intentional actions were reasonably likely, I submit to you, to provoke a belligerent response from those present. Isaiah to be closest and have the most background information. We talked about that. And from the get-go, Isaiah is trying to assist Fatima, who he believes to be in physical danger. And he's right? And notably, when you look at the self-defense instruction for defense of others, Isaiah entitled to protection under the same legal principles. So if anyone is entitled to defend themselves, it would be Isaiah. Those strikes by Isaiah on Ihsan do not occur until Ihsan is already strangling Fatima.
There we go.
There's a lot
I got to see
if he
some
hit
of
him
the
like
slides.
42 or 32 times, whatever number defense counsel proffered. That doesn't happen until after the fact when they're already on the ground. Isaiah has not struck Ihsan when Ihsan punches him in the head. There is the initial, and you'll be able to watch it in Exhibit 5. There is the initial contact, and when you look at that video, when you look at those photos, you'll see he's already dragging. He already has a hold of Fatima by the front of her hoodie collar, which is what Fatima described.
By the way, a lot of people are waiting for this new podcast or YouTube channel by Bob Alessi. There's been some hints, there's been some posts about it, but nothing yet. He keeps saying that there's going to be something. I'm sure there's going to be something soon. And we're all going to get to see what Bob Alessi has up his sleeve in terms of analysis, legal analysis. Or maybe it's not going to be legally based. Who knows? Maybe it'll be on how to improve your vocabulary. Who knows? And will Yannetti be part of it? Something tells me Yannetti's going to be somewhat part of it one way or the other. I don't know if it's going to be like a daily show, a weekly show, once a month. I don't even know what it's going to be, but I'm sure, I feel like Yannetti's going to be part of it one way or the other. Maybe like an occasional guest like I do with Solomon.
And Isaiah is trying to pull them apart. And see, there's another example of Isaiah, Ihsan dragging Fatima by the front of her collar, and she is pulling back, and Isaiah is trying to dislodge them. Exhibit 6. You go to Exhibit 7. All he is doing here is, again, trying to get him to let go of his daughter, who he has by the front of her collar, and is throwing her on the ground. That is what Isaiah is doing during the course of this interaction. And now Fatima's down. He's thrown her on the ground, and look at what Isaiah and Ihsan are doing. Isaiah's hands are out. They're out in the, what are you doing, man? What is happening? Oh my gosh. His hands are down by his side and they are out. And what is Ihsan doing? He's grabbing him by the front of the collar, and then bam. And look at Ihsan's face. Does that look like the face of an individual who is protecting themselves? Or does that look like the face of a guy who's real angry? Real angry that this kid had the audacity to interfere with how he has decided he wants to parent his child. I submit to you that's exactly what that face is. That has nothing to do with protecting himself and everything to do with exerting his anger and his power and control over this other child that is present. He's not being attacked, he's being thwarted, and he's being interrupted, and he doesn't like it. It's happening because Ihsan is mad. The force he uses is neither reasonable nor is it moderate in this case. It is not a necessary use of force in either the timing of when it occurred to protect himself, nor is it a necessary amount or reason.
Okay, we'll take a little break just for this question. For BC, if by some mistake any of the forbidden words is used in the trial, is the trial completely compromised? And the answer is, generally speaking, no. There's just a curative instruction that's given to correct that. So that's what usually happens. Back to the action.
Reasonable amount of force being used. So now we are at Zahraa Ali, count 2, assault in the second degree. That completes all of Ihsan's charges. We are done with Ihsan. We have hit a milestone. Element 2, pertaining to Zahraa Ali. The on or about October 18th, assaulted Fatima Ali by strangulation. When you look at this element itself, this count itself, you will note that there is only one type. Whereas with Ihsan assault in the second degree, we had 1A and 1B. We have those alternatives. For Zahraa, we only have strangulation. Again, October 18th, state of Washington, none of that changes. Intentionally assaulted. Exhibit 133. She intentionally grabs Fatima at the neck, not an accident. That mom is holding Fatima around the neck at about 2 seconds, grabs it again in 8 seconds, and then those screenshots show that location of her arms, like we talked about before, that she's being pulled backwards. That strangulation for assault too, or that's same behaviors, that is separate and apart. You also have that Fatima testifies she can't breathe. You heard Zayla Carter talk about how Fatima is trying to get up and run, and mom is grabbing her by the throat, and Fatima is pushing her away. Mom is not giving aid. Mom is not asking if she's okay. Zayla says she's just trying to grab her, and she's grabbing her by the throat. Athena immediately knows it's wrong, and she says so. Like, what are you doing? Mr. Leary asked her a question about whether it's mom or sister, and you remember you heard Athena go, it was mom, and then she goes, well, now that you're asking me, I'm putting the video, I'm not sure if I know if that's mom or sister, but she is correct. We know from the video it's Zahraa. Visible standing away from Fatima. So we know that Penny never puts hands on Fatima. As far as the video shows, we know that it's Zahraa the whole time, and Athena is correct. So yeah, the child, again, got confused in terms of the direct examination questionings by Mr. Leary, but you watch the video and you know that she is right. She says, Mom grabs her by the throat. And I said, what are you doing? You can't do that because she just watched it happen. Even Athena, who has no medical.
Okay, we're going to have to take a little break from the action because Blessed Mom in Texas apologizes for the first super chat. Could hardly read. A new phone. Love all your realness. Love too. All in the chat. Thank you very much, Blessed Mom in Texas. I'm looking forward to your email about the details of your case. Back to the action.
Training whatsoever knows that that is not proper, and Mom has done that, and she is correct. And then you have the testimony that Zahraa, she's holding on to her by the throat to both keep her from fleeing and to continue those efforts of Dad, and Fatima is fighting that as well. There's no indication by anything that we've seen in terms of evidence that somehow Zahraa is below average intelligence or has some sort of eyesight problem. Nothing that interferes with her ability to perceive what everyone else testifies about over and over and over again is clear and obvious, even to Josh Wagner, after Zahraa is already on scene, right? She knows that her daughter is unconscious. She knows her daughter is injured because they were her arms helping to do it. And she doesn't ask if she's okay. Just let me talk to my daughter. Those are grossly different response. And you saw the video of that. The grossly different response for the arrest of her husband and the strangulation of her child. And let's be clear, the state's not saying that there is some sort of anticipated, expected response, that everybody's response to an emotional situation has to be a particular way or it has to be consistent. We know that that differs from person to person. But when we're talking about Zahraa's response for the arrest of her husband compared to the strangulation of her daughter are demonstrated by Zahraa on body cam to be grossly different. And then we have the strangulation, the medical reports, the doctor and nurse testimony. So the physical discipline defense for Zahraa is the same analysis as it was for Ihsan. It's unreasonable to interfere with a child's breathing. That is an inference that you get to make based on that description. Nothing changes about the size, age, and condition of the child. And nothing changes about the location of the injury to Fatima. And that's same special verdict form for assault in the second by Fatima, or for Zahraa on Fatima. Count 4, burglary in the second degree. Burglary in the second degree occurs when you commit the crime of entering or remaining unlawfully in a building with intent to commit a crime against a person or property therein. That's the definition. Then you have the definition of enter or remains unlawfully. That is again in your instruction packet. You enter or remain unlawfully in or upon premises when you are not then licensed, invited, or otherwise privileged to enter. So enter or remain. Okay, that also means that when somebody has trespassed you from what otherwise would be a public place, that means that you are no longer licensed, invited, or have the otherwise privilege to so enter and remain. Instruction number 44, a person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime or person therein. This inference is not binding, and you decide what weight, if any, to give it. That means the state does not have to also charge underlying offenses and also prove those beyond a reasonable doubt. You get to infer, if you so choose, as to the defendant acting with the intent to commit a crime against person or property therein. And then there are your elements. October 18th, entering or remaining, state of Washington. This slide probably looks very familiar. Again, it doesn't change. Elements 1 and 3 happens on October 18th, it happens in the state of Washington. Backside of element 1, unlawfully in a building. How do we get to the point where she's unlawfully in that building? You heard the testimony on September 16th, that incident occurs with Isaiah campus. You hear that Celeste Walter corroborate that, and as a result, I trespassed Mrs. Ali from campus and all North Thurston School District property. You heard the testimony of Ms. Waltermeyer and Officer Howard on September 17th. Haneen comes to try and pick Fatima up early from school, and the school says she needs to stay and you need to tell your mom to come have a meeting with us. So later that afternoon, Zahraa returns. She meets with Celeste. She meets with Officer Howard in Celeste's office and is presented with that trespass order and those instructions about the order by Officer Howard. You have further that when Zahraa returns and they serve her with that trespass order and she's given those instructions, Officer Howard offers Zahraa the language line. And you heard what the language line is. The language line is, If you don't understand, the document that's been provided to you is in English. If you don't understand or you're not comfortable with that, we can provide you assistance. Would you like someone who speaks Arabic directly to be on the language line and have this conversation with us? You can choose to take it, you can choose not to take it, that's your choice. Zahraa declines the language line. She does not want the language line. Instead, she asks for Haneen to come assist. So Officer Howard and Celeste say, sure, we'll wait. So in the meantime, they're chit-chatting with her in English about a number of topics. And then Haneen, Zahraa's request, arrives and they go over the order a second time while Haneen is present and assisting. You hear the testimony that she's offered chances to ask questions. She is specifically identified to her the places she can and can't go. You can't go to the baseball field. You can't go here. You can't come to the building. You can't come to pick up your daughter. It's fine for Ihsan to come pick up. It's fine for Haneen to come pick up. This only applies to you. You are not allowed to be on the property, period. She has a chance to ask all of those clarifying questions about the parameters. She's given the phone number to call if she has any further questions. Defense counsel said, well, there's nothing on there that says she can appeal that decision, right? There's not. There's no requirement. And you're not going to find it in your instructions anywhere. It doesn't exist. She is given a sheet that describes what she is to do. She's been orally advised twice with the interpreter of her choice. She speaks English, to be clear. It may not be her first language, but there are consistent interactions with English. No one's saying that her English is great, but it is certainly enough. You heard Fatima's testimony. They've lived in the United States since Fatima was 6. So we're at 11 years at this point. And Zahraa is able to communicate in English with these women, and she has done so consistently. And that is described. But even with that, she asks for Haneen to come. They wait for Haneen, and they go through all of this. And that phone number is pointed out and identified. Here, if you have further questions, then call this number. And per Ms. Waltermeyer, that never occurs. There's no questions about it. It is a clear, self-explanatory order that is accompanied by oral explanation. And then you have that trespass letter itself at Exhibit 121. Then on October 18th, she violates that order. She enters or remains unlawfully in a building because she is not allowed to be in that building. You have that she arrives on campus where she's already expressly been told not to be. She understands that. Moreover, Haneen, the person that had that conversation while she was present, is with her. So Haneen knows as well. She's not there by herself. Then when Fatima escapes from the stranglehold, she chases her into the main office inside the school building where she is not allowed to be. She not only goes into the building, she goes into the office and tries to continue to go through the back. And you heard Tracy Arnold say, I had closed those doors and I was using my weight to try and hold those doors closed because I could still hear her and Denise Kinley yelling back and forth. She then leaves, and you see her in the video try and go through the side doors, and Principal Dean cuts her off. That intent to commit a crime, the entering or remaining is with intent to commit a crime against a person or property therein. She knows husband of just strangled is in there. She has demonstrated at this point her ability to physically assault a child. She knows Isaiah. She chased them. She ran after them. And we've heard it over and over again. In her story, there's no evidence to support that whatsoever. If anything, Isaiah is a kid in the story that everybody would, I think, like to have as their kid. He is kind. He is respectful. He is there to help out friends and look for danger to people that he knows are particularly vulnerable. And he demonstrates that on the stand. But she blames him and his family for everything. I submit to you, you heard from Victor Barnes. Victor is Isaiah. Listen, we tried to engage. We tried to have a reasonable conversation. We tried to be respectful about what the parents wanted, what Ihsan expressed he wanted. And so we said, you guys can't see each other. You need to take a break, right? And he was not like over dramatic by any means. He said, I understand that parenting is hard. right? Everybody agrees that parenting is hard. I think everyone would agree that parenting teenagers is not for the faint of heart. It is difficult for sure. And we've talked about that at length. But this goes well beyond that. And Victor says, I understand it's difficult, but you know what? They're teenagers and they're in love, or they think they're in love at least. What are you going to do, right? So we put some boundaries on it, we put some guidelines on it, and it didn't pan out. And this was the response. And for Zahraa, that is all Isaiah's fault. That is his fault, his fault, his fault. And so what is she doing? She knows there's a no contact provision. So what is she doing when she goes in there and chasing him in? She knows she's violating that order, and she intends to violate that order. She knows she has that with Isaiah. She has to stay 1,000 feet away, and she knows that he is in there because she watched him go into that building. The intent to commit a crime against a person or property therein. Again, I don't have to prove, you don't have to find what crime the defendant acted with the intent to commit therein. That's not in your instructions, and you're not going to find it because it doesn't exist. It could be any number of them: a further assault of Fatima, an assault of Isaiah, a further violation of the no contact order with Isaiah. You must only determine that the entry or remaining within the building was with the intent to commit a crime, but you need not actually identify that that crime has occurred. So there we know she's going in the building because she's actually in the building, right? Exhibit 110, page 6. We know she's in the office itself because there she is, bottom heading towards those back doors. There's Tracy Arnold, exhibit 111, page 9, running through to try and get in front of her because, as she said, when she closed those glass doors at the front of the office, main office, Mrs. Ali goes around her. And there she is yelling at Miss Kinley and arguing. Page 11. And still arguing with Paul Dean in front of that campus expectation sign. We know she's not allowed to be. Now, mind you, the burglary doesn't happen until she enters a building. The burglary itself is not for simply being in the parking lot or on the property. The burglary happens, in this case, when she enters the building, because that is the definition. Okay, so just make sure you make that distinction. Last crime, we're almost there. Count 5, violation of that no contact order with Isaiah Williams. So violation of the court order, you commit the crime of violation of a court order when you knowingly know of the existence of the order and you knowingly violate one of the provisions that's identified within that order. And you have, again, that element instruction in your packet. 4 elements altogether. We're going to go through those elements with the evidence that you've seen for each of those elements. 1 and 4, seen this, same instruction, right? Don't anticipate argument or significant argument, but you still have to find that the state proved it, and you have to find the state proved it for each count that exists, okay? So the court, here's the order, exhibit 36, page 1 that you have. You have the court that has issued that order. Let me go back up for 1 second. There existed a protection order. So let's look at the back half of element 1, existed a protection order. Exhibit 36, page 1, you have the court that has issued that order, Superior Court of Washington, Thurston County. You have the protected person or the petitioner, Isaiah Williams. Isaiah is 16, so as a parent, I have to petition on his behalf to protect him. You have Zahraa as the respondent. You have the effective date until October 24th at 9 a.m. And then you have this order restrains, and then Zahraa Ali. So clearly identified as the restrained party. It's not an overly complicated order to read. Then you have section 3 on page 2. Protected minor is listed on section 3. There's your section 3 when you're looking for it right there underneath the red dot. And that order protects Isaiah Williams. Page 4, here are all of your provisions that she is restrained from doing and clearly outlined. No harm to Isaiah. And the minor listed in section 3 above. No contact with Isaiah. Clear through a third person. No stalking of Isaiah. Passing, following, monitoring of Isaiah. You have the exclude and stay away by 1,000 feet from Isaiah. His school, himself directly there under D, element D. and then stay 1,000 feet away from the listed residence, and they put in their own listed residence specifically, because by that point they know, mom and dad already know where they live because they've shown up at the house, and you've heard Victor talk about that, right? That he tried to reason with them, he tried to talk to them, he tried to avoid this, and he was unable to do so based on the way events had been unfolding because they showed up at his house. So the elements that the defendant knew of the existence of this order, you have Officer Hang's testimony that he serves that order on October 16th. Remember that it is issued, let's go back. It's issued October 14th. That's when the order is issued. 2 days later, Officer Hang serves that order. Exhibit 37, you have that proof of service that Hang files with the court. And then you have Exhibit 38, the body camera of that service. He serves it on Zahraa at her home. You watch that. You see that Haneen is with her at the time of the service. Again, at her request, Haneen says, can I stay? I help my mom. Yeah, sure. The two women are communicating with each other back and forth about that order as Hang is describing it. Zahraa asks questions about it herself in English of Officer Hang. Haneen also asks clarifying questions. You know they understand that Mrs. Ali, Zahraa Ali, understands what that order is because she demonstrates that. He in fact points out the number to call in the document if she has further questions. He explains it to her in basic terms. He doesn't use overly complicated terms. And it's not a complicated document or set of directives to comply with or understand how to comply with. Moreover, you see her ask that clarifying question. Wait, so if this means I can't contact him, does this mean he can't come to my house either? She understands what the limitations of that order are. Does that mean that if I'm here and he comes to my house, then he gets in trouble too? Well, what does Officer Hang say is, well, if he comes to your house, like you have a right to be in your home, you can call law enforcement if that's the case, right? We know she understands the order. She asks that clarifying question. She provides alternative situations and is trying to decide how that order, those alternative situations fit into this order. So we know she understands what the limitations of that order is. And she has, again, her chosen interpreter present with her, and she's communicating with her throughout. She doesn't demonstrate at any point that she doesn't understand how she is personally restrained or demonstrate confusion about how she is personally restrained. And then you have element 3, the defendant knowingly violated that restraint provision, prohibiting contact, excluding the defendant from a school, prohibiting the defendant from knowingly coming within a specified distance of the location. So on October 18th at about 2:13 p.m., she's certainly within 1,000 feet of Isaiah. She's physically engaged with Isaiah, and she chases him and her daughter into Timberline High School, certainly within 1,000 feet. And then you have it again at 2:13. She's in 1,000 feet of his school grounds itself. So there's 2 separate provisions that she has violated. And then she knows exactly confusion about who Isaiah says his name. She tells Hang and Bell and Chavez, you see that in their body cameras. He goes to school here. She knows where Isaiah goes. He's a student here. Hanina just said, Isaiah James Williams. He's a student here, I'm pointing, right? She knows exactly who is protected by that order. There's no confusion. She knows exactly where his school is. There is no confusion. She knows she's violating that provision of that order. She just doesn't care because it doesn't matter to her. She doesn't care. There's Exhibit 134. There's Isaiah before everybody starts running. There's Exhibit 108, page 2. There's Fatima and Isaiah, Zahraa, right behind with Haneen behind. While Isaiah, page 109, again, you have them running, and I believe that's at 2:20 of that video, of the 2-minute and 55-second video. Again, you see Fatima and Isaiah. And at 2:41, 21 seconds later, you have Zahraa chasing after them. She's about 20 seconds behind them in her run, and certainly within 1,000 feet of Isaiah. So that is it. At the conclusion of all of your deliberation, I'm going to ask you to return verdicts of guilty on each of the charged counts and findings of yes for each of the special verdict forms for Ihsan and Zahraa Ali as the state has charged them. Thank you.
Members of the jury, at this time, the bailiffs will lead you back to the jury room. We anticipate a 30-minute break, but if you are not done eating lunch after 30 minutes, you tell the bailiff that, and we'll have a longer break. When we return, we will start with the closing arguments by Mr. Kading on behalf of Mr. Ali. Thank you for your time and attention. We're still just in this process. When you go back, all you're doing is eating lunch.
They were just like about to make a dash for the door. She's like, what? Wait a minute. No. Now you can go. All right. Okay, well, at least first part of the closing is done. And now we can take a little bit of a break. So question is really, if we take about a half-hour break, that's 4 o'clock. That's going to be like about another 2 hours of this, although I do have some other content I wanted to get out today. So I think we may just call it for today, although I did want you to see one more thing, and that was because I didn't really put it up there for long enough. So, well, actually, let me just pull it up because I think some of you saw it, but in case you didn't, give me a moment. Give me just one moment here. Because I know you guys wanted to see this, what I look like when I was a baby. So I figured I'll show you what I look like. I mean, that's basically it. I mean, you know, there's not really much more. There's not much more to it. That's the baby. It's the baby picture. As you can see, there's less gray hair. You know, there's less gray hair there. You know, but obviously I was in a suit when I came out. The tie needed a little bit of work, but, you know, I still had a tie because I had to be formal. So the glasses are pretty good. You know, you got the jersey. You know, you got to hand it to the Karen Reed AI channel because that's the one that did this and said that I can use it. Some people said it doesn't look exactly like me. Some people say it, you know, it does. I thought it's pretty good. I thought it's a pretty good shot. And I like that there's a lot of, you know, attention to detail, like my scales of justice. And I'm not sure what happened on this side. On the other side, there's only one scale there, but okay, this scale is good. And then, you know, you got the headphone, and you got the microphone, and you got the jersey in the back. Don't forget, you know, we got my jersey in the back. I mean, the number's different, but okay, you know. And then you got my diploma in the back. You know, this is a lot of thought, and this was a great one. So they actually made a few for me, the Karen A. Reed AI. I asked them if I can use it. I got, you know, 100% permission to use it. Maybe we'll make some BC swag with this little baby AI picture on it. I think that would be good. Yeah, exactly. So the number's a little bit off. The truth is that usually I like to be number 54. Some of you who have been following me for a long time know why I like 54, or maybe I just shared that with the members only group. But there's a reason why I like 54. But the jersey in the back, where right over my shoulder here, is actually number one. Number one, but that's for a different reason. And that one actually says Brother Counsel. The one behind me says Brother Counsel. So, but anyway, this is this was the baby AI. There are some other ones that they sent me also. Let me see if I can pull it up while we're talking so you can see those. Here we go. Here, I'll show you guys this before we call it a day. Here's another one that they made for me, Karen Reed AI. Well, I can't blow it up really anymore. They also made this one. So got a lot of options to choose from. Maybe we'll put one of these on a t-shirt or something. But yeah, I like their work. But anyway, all right. So listen, we're not gonna stick around for the closing of the defense. I got some other content I want to get out today, so I'm gonna work on that. And I'm really sorry, but it was nice of everyone to join us for the prosecutor's closing argument. And look, you know, it's not easy. You know, you got a lot of things, you got a lot of elements, you got a lot of charges you want to get through. You want to get through the verdict form and everything, you know. So, you know, cut her a little slack. I'm sure after she goes to BCU, you know, it'll be sharper, it'll be better. But you can't expect perfection from everybody. You know, it's if they went to BCU, okay, but you know, we'll make it available for her if she wants. So the defense is going to close next, but I'm going to have to pause for that because I want to work on some other content. All right. Thank you, everybody, again, for joining us today for this closing argument, for the prosecutions at least. I think we kind of all know what the verdict is going to be. That video speaks 1,000 words. And we'll see you guys by the next hearing, and we'll see you by the next trial. I know we have Ailton coming up, but we're gonna keep pumping out the content, so don't you worry. All right. Well, thanks again. It's been fun always. It's always been fun, and we'll see you guys at the next one. Take care.